not allowed to start that early, so we're going to have a couple minutes break here. Sorry about the scheduling, but that's just how things work out. So in a couple minutes, we'll start that hearing. Thank you. Okay. Holy cow. Go ahead and start with.
On the bottom of that is the sheet. I need that back.
You shut this down for the whole day. We're gonna have to leave.
I feel like I made something all the way.
We'll probably find out.
We'll find out when something doesn't work, right?
Today's the 6th.
It is.
The first thing, 9:35 is a public hearing for the Randy Loberg appeal. Who's Randy? Okay. Okay, if you'd like to come forward, please. A seat at the table, please. If you'd use that microphone so everyone in the room can hear you, and anyone that speaks during the public hearing We would ask that you state your name and please come forward. It's easier to hear from up here, but we need your name for the record if you do speak during the public hearing portion. And address all of your comments to the chair, not to anyone else in the room. Thank you. Okay, you'd like to go ahead?
Okay, so I, had, gotten information from the planning and zoning committee and I didn't agree with them, so I put in an appeal. And, part of that letter is in, June of 2022, I went to the planning and zoning committee. I asked them if I could use my home as a rental and they said, yes, I could. So I went ahead and I did my bookings and such. And then I've heard nothing from them until April 5th of 2023. And that letter had stated that I was in violation of even advertising my home as a rental and some other permits. And so I guess a lot of this is just a confusion on the fact that I was told one thing, I carried on, did what I was doing, and then had received notice that it was just all changed. So I guess I was needing to get clarification on that today.
Okay. I think if I read the appeal correctly, part of it was the also, can you address the part about residing in another building on your parcel while you were renting it?
Right.
I think that was also part of the violation, if I read it correctly.
That is correct. And
Okay.
I went down and I talked to him about that and I discussed that with Kim. And I told him that I would make arrangements not to be there since it was an issue that I couldn't be there. So I have made that arrangements to not be on the property, to stay at night. I have to be there during the day. I have too much yard work to do as far as maintaining it, so I can't be gone for long periods of time. But I don't have to be there at night if that's what the request is.
Okay. I just have one other question, I guess, and it's kind of a clarification, but I'm not sure we've got all the clarification we need yet. But
Right.
when you asked about renting your property, was the term short-term rentals used in that conversation, or did you just say renting?
Okay, so the only discussion I've ever had with the planning and zoning committee is on a short-term rental. That's the only reason I've even talked to them. But to clarify each time you talk about it as a rental and say short-term or rental, I mean, it's just, I've never came to them for anything other than a short-term.
Okay. All right, thank you. Does planning and zoning would like to speak, please?
Okay, are you done with me?
Thank you. Well, for now.
Madam Chair, Joy Hill, Planning Director, and I've got Kim Dillevin, the Assistant Planning Director. I first want to say thank you to Mr. Loberg for exercising his right to appeal. I understand that the planning department makes decisions and we want people to make sure that we're doing it right. So I appreciate that he's taken the time to do that. The record on this particular situation is a little bit lengthy. Complaints started in August of 2021. At first, it was that Mr. Loberg was living in an RV on the property. Then it turned into Mr. Loberg was living in a shed on his property and having his home rented out. So in early 2022, staff did say, according to the record, that Mr. Loberg was operating short-term rental. That's what he wanted to be doing. And staff said that he had the right to do so. In April of 2022, I conducted a deep dive into all the residential and rental and lodging regulations in our rules, because we continuously have been having problems with short-term rentals. So I went to the county attorney's office and we did a deep dive. We pulled all of the housing, lodging, and rental definitions out of the regs. And also in that time found that Mr. Loberg lives in a subdivision that is under a planned unit development. That's a PUD, which, as you know, those were kind of unique approvals that happened decades ago, where it was a specific agreement between the landowner and the board. And so in this particular case, the PUD very strictly limits the use of the property to a single family dwelling. It's not allowed to have any other residential use of the property. And as far as business is related, it does not prevent business use so long as it is not a nuisance on the property. But the primary principal use of the property must be a single family dwelling. So that leads us into what is a single family dwelling? What is a single family residence? What does that mean? Well, if you break it down into the simplest terms, single means one. Family, we have defined in our rules, which says a group of individuals not necessarily related by blood, marriage, adoption, or guardianship, living together in a dwelling unit as a single nonprofit housekeeping unit. And then, of course, we get to the word dwelling, which is a housing unit, a place to live. So does that mean that a single family residence can be used for profit? By my definition, where it says a single nonprofit housekeeping unit, I would say no. It would not be expected that you would publicly advertise your home, your principal dwelling, for a business use, which is to sell the use of the rooms in your home for people to stay on a transient basis. So if it's not a single family residence that he's operating by doing short-term rental, then what is it? So we have to look at the rest of the definitions to figure that out. So nothing else under residential fits. It's not a mobile home. It's not a multifamily unit. It's not an accessory unit because it's primary on the property. That leads us into residential businesses. Well, is it a home occupation? Well, it can't be because he's not occupying the home. Can it be a cottage industry? It can't because he's not occupying the home. It's not a bed and breakfast because he's not occupying the home. So then we're led into the commercial category. And under commercial, we have hotel motel or a highway commercial business. And a hotel motel is defined as a facility offering transient lodging accommodations to the general public. We don't have a definition for transient. We have some definitions for lodging. For instance, a lodging room, a room with one or more beds, bunks, or other facilities for sleeping purposes for an unspecified number of persons to provide short-term lodging for a charge to the public. That is exactly what he is doing. He is offering short-term lodging for a charge to the public, which is not a residential use. So that puts us into highway commercial business, which, as you know, they are prohibited in most planning areas in the county. But we're not under a planning area. We're not under a zoning district. We're under a PUD, which is our zoning. So we're back to single family residence, which is the only thing that's allowed. And so that's where we left it. So in our early letters to Mr. Loberg, I found it was unclear. And I consulted with the county attorney because I said, I got a problem. I sent out this letter to this guy last year because he was living in the shed, or he had an RV in his property that he was living in. And then it turned into the shed, and then it turned into septic, and it turned into all these different things. But it was never clear for him the rental of the home. And so we sat down and we crafted the letter to make sure it was clear that he should not be doing a short-term rental of the primary residence. So that was what the last letter was about. It was to provide clarification that I think unfairly was not provided up to that time. So that's where we lie. And once he received that letter, that is when he decided to appeal that decision, which was reasonable for him to do. I do want to mention that, you know, we have had neighbor complaint since 2021 from the neighbor next door. He may be here today, I'm not sure. We have received a letter from his attorney also mentioning the PUD and the covenants that are in place on this particular subdivision. As you know, the county doesn't enforce covenants, but it is recognized that there are covenants in place on this particular property. So with that said, Kim, do you have anything else to add?
Just, Madam Chair, just a couple details, and unfortunately I'll probably reiterate some of what Joyce said, but I'll try to be brief. So again, history. So this isn't a PUD.
Would you identify yourself?
Oh, yes, I'm Kim Dillman, Assistant Director of Planning and Zoning. So this property is in this PUD that we're speaking about. That was created in 1995. As Joy mentioned, it says in the PUD document that the primary uses of property shall be single family residential, and it says other uses permitted in what is called the residential single family classification. And it also says under standards in that PUD that the number of residential uses, it says one single family residence. So again, that speaks to the fact that Mr. Loberg, in our opinion, should not be living in the shop, should not be living in an RV, talks about that. Then, so this PUD was in 1995, so that classification that it talks about, residential single family, that comes from the standards and regs that were in place at the time, which was from 94. And in those standards and regs, under residential single family, which the PUD says should apply, it says business uses, retail or service, are not allowed in that PUD. I would argue short-term rentals, possibility of making hundreds of dollars a night. I don't know what he's charging. I would argue that is a service under a business use. The regs, the PUD essentially says that that is not allowed. Neither are hotel motels, which is transient lodging, like I think what Mr. Loberg is doing. So I think to me, it's clear with the PUD and with the regs in place at the time, this is not allowed. And in our letter that we sent out in April, we say he's in violation of our regs. Well, our regs, of course, talk about in a section where we have to comply with any PUDs that are currently in existence. So that's what we're trying to do, comply with this PUD.
Thank you.
Finished. Thank you, Madam
you.
Chair.
Any further questions for us?
Any questions for staff?
I guess so. I mean, we're heading down the short-term rental path and trying to go cautiously, but would it then, under your definition, is any single-family residence not allowed to be used as a short-term rental?
Madam Chair, it's our conclusion that if the primary use of the property, meaning the greatest floor area, the greatest acreage, the greatest amount of use of the property, if it is a short-term rental, then that is a commercial use. And most places you either need an SUP or it's prohibited for that use.
Okay, so to answer the question, your opinion that any house that's a single-family residence in Park County cannot be used as short-term rental.
Any primary residence could not be used as a short-term rental unless it had a permit for a highly commercial business. You could have an accessory house, right? You could have another housing unit that potentially could be used as a short-term rental, which is it's not primary, right? So it's subservient to the primary use of you living there. That could be a short-term rental. That is how we understand it.
Okay, so that's gonna have some far-reaching ramifications if that's.
And right, and that was, Madam Chair, one of the reasons why years ago we dove into the short-term regulation or short-term rental regulation discussion with the public to find out what is really the difference in a neighborhood, of operating short-term rental versus just people living there full time. And we all know well that there are differences between the two. I just think, one thing I've struggled with in my early years here is just, it's not, we don't have a short-term rental section, right? It's not perfectly clear. So you have to piece together all of the different definitions to come to that conclusion. And that's difficult, right? It's hard to tell people that. It's hard to say, look, you're operating a business. And so long as you're not living in that structure, occupying the structure, it's not a residential business. It is commercial. And so it took a lot of discussion. It took a lot of deliberation with the county attorney's office. It took a lot of research in general to come to that conclusion. So we didn't come to it lightly. We took a lot of time in making that decision.
Yeah, the reason there wasn't a short-term regulations is because short-term rental regulations, it's a new thing. It's a relatively new
Right.
thing. Yeah.
And so, that's why we're diving in deep.
Any other questions for staff at this time?
Just when you originally told me, Mr. Wilbur, that he was okay to do that, you just, was that, you did it in writing, I'm sure, and that it was approved, and then afterwards you found out that it wasn't.
No, so Madam Chair, in our violation report and in our call logs, a staff member had talked with Randy and at the time told him that rental was his right. I don't know if at that time they were aware of the PUD even, and certainly not aware of the deep dive into the rule. So I could not say what specifically was used for that, but I would guess that it wasn't even aware of the PUD.
Again, once again, PUDs pop up.
Yeah.
We don't have a lot of them, but they always seem to rear its ugly head.
Kind of like the LUCs. Yeah. So in, just one more point of clarification. So in your estimation here, anyone in the lands under that PUD, they own the house, but would not under any circumstances be able to rent the house and be gone for a year or two. Is that,
So, Madam Chair, now I think you're getting into the difference between short-term rental and long-term rental.
Yeah.
Okay, so long-term rental is defined as 6 or more months
Mhm.
on a continuing basis.
Mhm.
So then we get into the question, well, are you making a profit or not on a long-term rental? I can't answer that. You might be breaking even. I have no idea. To me, long-term lodging is a completely different impact than having a new neighbor practically every single night.
Mhm.
So when we talk about long-term rental of a home, it's essentially the equivalent of you living there full-time. So it has been looked at that way. That's the way. And further, I would think the county would not be favorable to not allowing someone to long-term rent their home under the circumstance that we have a housing deficit in Park County, you know, so I mean, a lot of people are able to offer housing for long-term purposes simply by buying a home and letting people rent it. But the impacts are definitely different on a long-term rental than they are on a short-term rental.
thank you. Any other questions for staff at this time? Okay.
Thank you.
So at this time, I would open it to public comment. Is there someone that would like to start? Okay, remember to please state your name for the record and speak into the microphone if you can. And we're gonna limit these to just a few minutes, and if you'd please not repeat what we've heard from others, that would be appreciated. Thank you.
Okay, my name is Mike Roberts. I live at 20 Shoshone River Drive. My wife and I live close, we're next door to Randy. Before I say anything else, I need to say that this is not personal. We like Randy. He's a great guy. He's been a nice neighbor. He keeps the place looking good. We haven't had any major problems. But it's not about whether Randy's a nice guy and we all like him. It's about whether a short-term rental business is in accord with the PUD, and it's not. The PUD has been in effect for 28 years. It specifies, among other limitations, single-family residential use. No matter how hard you try, you cannot cram short-term rentals into single-family residential. In a tourist season, there can be 30, 40, 50 different groups renting that house. 50 groups is not single-family, however you look at it. If you take a very narrow view and just look at it a night at a time, that night might be a single family. It might be the 3 couples that like to travel together, or the 2 families who want their kids to experience Yellowstone together, or the 5 motorcyclists headed to Sturgis. None of those are single families. Even on those nights when there is a single family renting the house, when Randy was living out back, there were still two families on that site and 2 dwellings. None of those can be made to fit the definition of single family residential. The PUD was in effect long before any of us bought our properties. What it does in effect is bake into those properties certain limitations of private property rights. Or you might look at it as certain rights being plucked out before the properties were sold to us. One of those rights was running a short-term rental. When we bought our properties, we didn't have the right to do that. And when we bought, we were agreeing to those limitations, buying into those limitations and agreeing to live with them. If any of us had serious heartburn with the PUD, we would have bought elsewhere, but we didn't. If we allow a short-term rental, how do we say no to the next owner who says, I want to open one, and the one after that, and the one after that? A road with a bunch of short-term rentals is not a neighborhood because those people aren't neighbors. They show up today, they leave in the morning, a new group rolls in tomorrow afternoon, and it just goes on like that. They don't care if it's a good place to live. They just want a place that's fun to stay for a night or two. So that's very different from neighbors. Paula and I, when we bought, didn't intend to buy into a place with short-term rentals. Lucky for us, the PUD I believe, prohibits them today, just as it has for 28 years. Again, it is not personal. We like Randy. We have no interest in seeing Randy punished in any way. We just want compliance with the PUD, including no short-term rentals. And that's it, commissioners. I want to thank you for the opportunity to speak today.
Thank you. Yes, ma'am.
Good morning, everybody. Thank you for your time and for listening to me. I first want to confirm that you've all received an email I sent on May 10th to each of the commissioners.
Your name, please.
Oh, I'm sorry, Janet Kempner,
Yes.
resident of Park County. Has that
I
email?
believe we did.
Okay, very good. Obviously, this is could potentially be bigger than just Mr. Loberg. And I understand, and I do want to thank Joy and Kim for their efforts in going through it's a very complex issue with a lot of emotion attached to it. Short-term rentals in Park County and in the city of Cody, which it's permitted. What I've heard this morning is a lot of focus on the PUD. But at the end of the day, the conversation about the PUD is all focused on definition of single family dwelling, which affects every single house in Park County. Kim and Joy, their definition is that it is a single family nonprofit unit. But the group staying in the home on a short-term basis is a nonprofit unit. If the argument is that the owner is profiting, then there is no difference between a 2-night stay, a 6-month stay, a year stay. How do you define what profit is? Joy also this morning said sell use of rooms to transients. That's not what a short-term rental of a single family dwelling is. You are not renting one room to one member, another room to another member. It is a nonprofit unit staying in the home for a short period of time. And I see no difference between that definition and someone who's there for 6 months. The covenants in Mr. Loberg's case do not prohibit short-term vacation rentals. There's nothing in there. There are covenants in Park County, like in Cody Country, that specifically say, very specifically, no rentals less than 6 months in duration. That is not the case here with Mr. Loberg. Again, this is really important that this has gotten right, because it's the tip of the iceberg. If Mr. Loberg's appeal is not if it's not granted and he's not given the ability to continue his short-term vacation rental, that affects many, many homes. I'm also a licensed realtor with Richard Realty. We have many listings, as does every other brokerage house in town, that specifically advertises that the home has a long history of successful short-term vacation rentals. There's value to that. If you take this away from every home in the county, those values will plummet. And we are all now paying taxes on higher values. That will go away. I just want to make sure I cover everything here. Yeah, so at the end of the day, it's very clear. What is the definition of single family dwelling? And I wholeheartedly disagree with Joy and Kim's interpretation, and I hope you all do as well. I have looked into other counties, and the city of Cody itself does not define it the way Kim and Joy do. So it's the beginning of potentially a tremendous can of worms for the county if you do not allow Mr. Loberg to continue his short-term vacation renting.
Thank you.
Any questions for me? No? Okay. Thank you.
Anyone else that would like to speak as part of the public hearing? Yes, ma'am.
Good morning, Madam Chair. I'm Jaylee Meineke from Meineke and Sits. I think I've appeared in front of all of you before today. I agree with a lot of what everyone has said. This is a difficult situation, and I don't think this is going to be the end of the debate today. The short-term rentals is a hot issue out in the county, within the city, everywhere. So to take the direction of Madam Chairman, I won't reiterate anything that's already been said because I don't necessarily disagree with anything that's been said. Other than I would say this, I do not believe that making a decision in this particular situation reaches out into a definition of a single family residential dwelling for the rest of the county. You are being asked to make a decision in a planned unit development. This is a very unique animal. These are old, but not that old because we have the planned unit development over in Trailhead that is relatively new. Each one is unique. Each one, is kind of its own individual situation. But it has a planned unit development agreement associated with it. It's a contract. It's a contract between the board and the developers. So even though it is old and antiquated, and I realize that it might not necessarily address all of the issues that are developing within Park County, such as short-term rentals, it is still valid. It is still enforceable. So you have to enforce it because you're a party to it. So what does that mean? You are being asked to act as a tribunal here and, make some decisions about the definitions of these terms, even though they're old and antiquated and may not necessarily keep up with the times. To kind of simplify it, I sent you a memorandum, and in that memorandum, I kind of isolated it to, well, what's the difference between non-residential and residential use? Non-residential classifies it as, anything that's rentals for 6 months or less, which is what's going on here. The other thing I think that you must take a look at that I think kind of gives you a little bit of a reprieve from this, if you make this decision and you do not allow these short-term rentals, you're making this county-wide decision that's going to affect everyone and it's going to set this precedent. I don't think that's true. You're setting a precedent for this PUD because you have a specific agreement to enforce. That's not true throughout the county. There are other things at play there, other issues to deal with. But this PUD agreement specifically says that no businesses are allowed that would constitute an annoyance or a nuisance. That is exactly what is happening with my clients, Steve and Talberry. They live right next door. It is an incredible nuisance for them. There are family after family after family rotating into this place. There's a fire pit and a large outdoor area, which is very attractive to the short-term renters that come in. They're often out there late hours of the night having a fire, disrupting the neighbors. I gave you a long list of just some of the instances of the times when Mr. and Mrs. Berry have been disturbed by the short-term renters next door. And what has been stated prior to now is true. Those people don't care if they're disturbing the neighbors. They're never going to come back. They're never going to see Mr. and Mrs. Berry again. So they don't care if they come knock on the door at midnight looking for their dog. It's not a neighborly experience. So it certainly is a nuisance for Mr. and Mrs. Berry and the other neighbors, which is absolutely not allowed. So you can decide that on a case-by-case basis. And that gives you enough, I think, ammunition here to say, I think this violates the PUD agreement and we're not going to allow short-term rentals. So I would simply ask that you really isolate it to this situation, this particular planned unit development agreement and what it prohibits, and not go into the sticky wicket of what exactly does a single family dwelling mean for the rest of the county? What does that mean for this zoning area or this zoning area? I think that's a way for you to look at this in a way that's less troublesome for everyone. And finally, what the gentleman that spoke right before me said is very true. This planned unit development agreement has been in effect since the early 90s. It's been of public record since the early 90s. The reason that we have those public records is to put people on notice about what they're buying and what the rules are. So if Mr. Loberg did not want to abide by these rules, then he should not have purchased the property. And just as a case in point, you know, my husband and I had a house in Trailhead subdivision for 10 years. We just sold it last year because we are only there part-time. We could not rent it out on a short-term rental while we were gone. So last year we sold it and we're buying a house in town in an area that allows short-term rentals so that we can exercise those privileges. But we did not do that in the Trailhead subdivision, you know, kind of surreptitiously, because we weren't allowed to do it. And so there are a lot of options for people who want to operate short-term rentals in Park County, where there are restrictions against it. There are areas that it's clearly allowed. And so if Mr. Loberg wants to operate a short-term rental, there are certainly options for him. And I would just leave you with that if you don't have any other questions.
Any questions, Mike?
I'm not sure. The problem I run into is anything that constitutes a nuisance or annoyance. Who defines that?
Well, if we were in a purely legal setting right now, if I was arguing this case to the court, it would be the person who's being annoyed. And that would be defined by something that would diminish the value of your property or the enjoyment of your property. That's basically the legal definition without a lot of legalese.
And that's extremely subjective.
It absolutely is. It is. If you
what might annoy me might not annoy you.
That's true, but I have a feeling that we can use our common sense to dictate what's, you know, normally a nuisance and annoyance. If you're awakened quite frequently, 3 or 4 times a week by rowdy, noisy neighbors, I think that's pretty common, you know, would be commonly considered a nuisance. And also, I think that if you look at it from the point of view that a nuisance is something that devalues your property, put yourself in the shoes of some of these neighbors who have to market their property right next door to a short-term rental. There are going to be some people who that is not attractive. They won't pay as much for that property. And so then that would be classified as a nuisance under the legal definition.
Again, extremely subjective.
Absolutely.
Because someone
You're
else
correct.
might find that appealing.
That is true. If you probably wanted to run a short-term unit rental yourself, that would be attractive. Certainly, there's circumstances where.
That's what I'm saying.
Yes.
That's what I have. So one of the problems I have is what a nuisance or annoyance is, the definition thereof.
Yeah, there isn't one in our regs. And as I stated before, you're being charged with acting as a tribunal here, which means you have to kind of act as the judge and define these terms. Although it's subjective, that is your role in this situation, unfortunately. And I don't want to be in your chair, so I don't necessarily admire that. But I'm just kind of saying that if it was me, I would try to just be very isolating of this particular planned unit development agreement and what it means, so you don't have to be overreaching into other areas and other definitions.
Any other questions? Thank you.
Thank you.
Anyone else that would like to speak? Okay, we need to keep moving here. Okay.
Good morning. My name is Paul Gill, and I live at 43 Harmony Road, also in the Shoshone River Estate subdivision. And my wife and Pamela and I share the longest common property line with Randy, over 100 yards. And in all the time that I'm strictly going to rebut what the previous speaker said. Unlike her, I actually live there. And we have never had any issue, disturbances at all with Randy's guests. Sure, they might be out using the fire pit. Well, if you lived there, Randy might be out there using it too. What's the difference? At the time when Randy informed me that he was operating an Airbnb, at the time we had a horse and a couple of mini donkeys along that common line. And I simply asked him to tell his guests not to harass them, feed them, do anything. And we never had any problem with it. We do not have air conditioning, so our windows are open whenever the weather permits, and we have never been disturbed by people in the middle of the night rousing around in Randy's backyard. So I just want to make that very clear from someone who actually lives there. We don't have a problem with it. Thank you very much.
Thank you. Yes, ma'am.
My name is Margie Pauley and I live directly across the street from Randy. And I've lived there longer than two other speakers that have came up here and spoke. And I've never had a problem with Randy's guests, with Randy. He has one of the nicest properties in our division. From my understanding, there has never been a complaint against Randy until the new neighbor moved in. So in the existence of his Airbnb, not one person has complained ever. I've never had to walk across the street and say anything to Randy. Randy came to all of us when he started it and spoke to all of us and stated he was going to start his Airbnb, and none of us had an issue. He started it and he said, if you ever have any type of problem, please come and address it with me. I will take care of it immediately. The individual who is making the complaints has just outrageously been obnoxious with multiple neighbors, with people pulling up an RV and just filling up their water from their friend's home. And he comes out ranting and raving about the blocking of the street. So this individual is just unhappy to be there, not only with Randy, but he is pinpointing Randy to close down his business with. None of us, until to my understanding, has found him a nuisance at all. Not once.
Thank you. We've only got a couple minutes left before we have another public hearing, so I'll have one more person and we'll have to decide how we're going to move forward.
Hi, my name is Casey Schwartz, and I just want to address the definition of the single family dwelling. I'm a realtor here in town. The definitions of single family dwelling along with multifamily or townhouse or condo, they are to define the structure, not the use. We then look to the covenants and the zoning to determine the use. If we are going to start implementing definitions that affect the use, it is going to have wide-reaching ramifications for everyone. And the freedoms that are going to be restricted of the property owners in Park County are catastrophic. It is not okay. It should be a universal term, what single family dwelling is. Then we need to look, and if you guys want to restrict it through zoning, then exceptions are allowed. Then we can go through conditional use or variance, and it's not a blanket. You can't do this. And I think that needs to be addressed and definitely taken into account.
Okay. Thank you.
Can I just have a quick point?
Sure. 2 seconds. Well,
I'm Donnie Anderson. I don't live in the area. Randy is just, he gave me a couple beautiful granddaughters. I've sat here and I've listened to this and we've talked about this PUD. I was on city council 8 years and we have a PUD mentioned of Trail Creek. Trail Creek does have a bed or Airbnb in that subdivision, and it was approved while I was on council, and it was approved because the neighbors all spoke up and said, it's all right. This man's got to make a living. And that's where we're hanging right now. Randy's trying to make a living. Our taxes, as you all agree, have gone plumb sky high. And I just think it's awful tough to restrict a guy on how he can make money to pay his taxes. And as long as the neighbors are okay with it, that's fine. Our neighbors are just as close family as you can get. And that's how you ought to act as a neighbor, as family. If you have a problem with a family member, you don't throw them out. You get together with them and you talk over your differences and see if you can't come to an agreement. And I think that's what we need to do here. I thank you very much.
thank you. Okay, we're at our 10:15 limit. What's the choice of the commissioners at this time?
Madam Chair, I'm ready to make a decision. I could close public hearing and make it very quick.
The others ready to make a decision at this time, or do you?
You're not? I've heard enough, but I still move to close public hearing.
I'll second that.
It's been moved and seconded to close the public hearing. Any further discussion? Hearing none, all those in favor?
Aye.
Nay.
You said aye.
Yeah.
So I have 3 ayes. Public hearing is closed. Okay. It's the desire of the commission.
Well,
I was just gonna give full disclosure here. I'm hoping to stay out of that. A lot of you know that I am the next door neighbor to the west. So I'm trying to not be involved in this other than running the meeting as much as possible, because it is the area that I live in also.
Madam Chair, if I could real quick, and I'll make it very. About 2 years ago, we went through this. The big elephant in the room is the short-term rentals, of which we agreed. We started a public discussion about 2 years ago. We agreed to kind of table that until the land use plan for re-regulation. Staff has already admitted the definition of short-term rentals are a bit taken out of context of bits and pieces of our current regulations that don't currently address that. If the appeal letter states, as far as the PUD is 2 people living there, he's agreed to, I have made arrangements to stay at the different residents during this. At this point in time, I don't think that we should, I would like to move to grant his appeal for the variance, or not variance, but grant his appeal for the violation.
Madam Chair, I'll second that, but I think it goes back to the letter that he got back in 2022. Where it said it was okay. This whole thing could have been avoided. If the planning and zoning had looked up and saw the POD and said, no, you can't do that, and told him at that point, but no, you can't do that. But he went ahead and began first at least notifying the neighbors and letting him know that what his plan was, set it up so that he could do the rental. So I think it all comes back to us to begin with, that we allowed him, and then, oh, by the way, you can't do that. And I think that's what the issue for me is, we just didn't look far enough ahead to the POD and the regulations that came with it. So I'll second that motion.
Been moved and seconded to approve the appeal. Any further discussion, Commissioner?
Just one question for Mr. Loberg. Did you buy this property with intent to rent?
No, actually, when I bought the property, I was working at Cody Laboratories, and was under the assumption that I would be able to have a very long career with him. And when they pulled out and left 80 people with no jobs here, it was hard to find something. My daughter moved out. It's a 4-bedroom, 3-bath house. I felt like I should take advantage of that situation, stay on my property, and utilize it to the best of my ability, and that's what I did.
Commissioner?
I just want to say, there were some very valid concerns here all the way across the board, both pro and con. But those don't need to be decided today. Those moving forward with the land use plan and the rules and regulations, we can put a more definite and with more input to get a definite answer. Doing one right now today, I think is wrong decision. This appeal is valid.
Any further discussion on the motion? Okay, all those in favor of the motion to approve the appeal?
Aye.
Aye. Those opposed?
Nay. Yeah, I'm opposed.
Okay. Makes it a little tough, guys. My feelings right now are that we are dealing with a PUD that was approved on the property, not a short-term rental issue per se throughout the county. Can it have ramifications on the future? And what happens with short-term rentals? I don't think so, because this PUD is unique and was recorded in the early 90s, as was stated, and what was approved for neighborhood type uses. I'm gonna vote against the appeal. So it does not pass. Okay. Okay, the appeal fails. Thank you. We need to move on.
Twenty 25.
Thank you. Thank you.
Yeah.
$25.
Okay, if we could take the discussion outside, please. We do have to have another public hearing that starts. Sorry. Sorry. Okay, our 10:15 agenda item, running a little bit behind, public hearing for the amended plat of Wagler, simple subdivision number 188.
All right. Thank you, Madam Chair. So the applicant for this process is Kim Wagler. This property is in the Lower South Fork planning area. The zoning district is GR5. We did receive an amended plat application from Mr. Wagler in February this year. Then we received a revised copy of the amended plat, which you all saw. It's in figure 1 in April of this year. So Mr. Wagler wants to partially vacate and amend this plat. It would be 2 lots. It'd be original lot 1, original lot 2, lots existing now, and it affects an unplatted parcel essentially to the north. So what happened would be, if this is approved, vacating a portion or along the northern boundary of the original lots 1 and 2 to be merged with this unplatted parcel to the north, shifting the boundary line between the original lot 1 and lot 2, shifting that to the east, and merging lot 1 with a 3.3 acre portion of the unplatted parcel to the east. What would result would be 5.3 acres that would now be called lot 101, which was originally part of lot 1, a 5.14 acre lot to be called lot 102. Part of that was original, obviously, lot 2. And both of these new lots, 101, 102, if it's approved, would be for residential use. History, the Wagler simple subdivision was approved in 2010 by the Park County Board of County Commissioners. Lot 1 and Lot 2 are both owned by Kim Wagler. The unplatted parcel is owned by Kelly and Teresa Marager, husband and wife. Marager. Sorry, Madam Chair. And again, you see in figure 1, you see what the amended plat would look like. Location of this property, it's shown in figure 2. The current lots are approximately 2.5 miles southwest of Cody. They're on the north side of Highway 291, which is South Fork Highway. Site characteristics: proposed lot 102 is residential vacant land. Proposed lot 101 is developed. It has at least 1 building, a shop, and it might be partly a residential unit. I'm not sure, but also it has a septic system. Topography is rolling hills, does have a decrease in elevation from south to north. There's a river ravine in the area labeled as Wagler Draw, shown on the amended plat. Neighboring uses you can see in figure 4. Surrounding land uses, Madam Chair, I should say topography is shown in figure 3. Neighboring uses are shown in figure 4, primarily residential to the east and south, ag lands to the west and north. There are some BLM lands in the vicinity. There is a subdivision to the southeast. This is, as I mentioned, the property is in the GR5 zoning district. These new lot sizes as proposed are consistent with that district. They're both over 5 acres in size. Again, this is a partial vacation and an amended plat. This is allowed in a regs that talks whenever someone wants to adjust boundary lines between platted lots and adjacent unplatted parcels. Has to go through the partial vacation. An amended plat is required to show this new configuration. In our regs, it talks about an amended plat has to be approved by the Board of County Commissioners. It's a in terms of these things, as you know, it's a question whether or not it has to be a public hearing. We determined that a public hearing in this case would be necessary, not only because of these two lots, but also the unplatted parcel. So we recommended a public hearing be conducted. We have in our staff report, bottom of page 5, where it starts about the amended plat process. Of course, we have to have an amended plat. We received that. There is a fee. Those things were provided to us in February. Again, our planning director determined that a public hearing in this case was the best path forward. Those public notices were in the Cody Enterprise on May 18th and May 30th. On May 18th, we sent a notice out to neighboring property owners consistent with our public hearing requirements. We notified agencies. Cody Canal responded. They said they're working with the applicant. Park County Treasurer responded. They said property taxes are paid in full. Park County Weed and Pest responded. Mary did an initial inspection. Said she will not require a weed management plan. However, she does recommend the applicant follow best management practice for controlling noxious weeds. Game and Fish responded. They have no wildlife comments. Public Works responded. They said in their response, they have no comments or questions regarding the amended plat. YDOT responded in May of this year. They said the existing access off of the highway to what will be proposed lot, or what will be lot 101, is currently permitted as a residential access. Said pending site review, YDOT said they would likely be able to permit a residential access only for lot 102. But an access application at the time, they said, had not been submitted to them. Overlay districts, this property is not in any overlay district. We've not received any public comments. Plat Review Committee met the end of April this year. We have, towards the middle of page 7 of our staff report, we have a list of the things that occur with the amended plat process. Again, a fee, public hearing was required. This new amended plat is titled the amended plat of Wagler Simple Subdivision 188, lots 1 and 2. As I mentioned, amended lot 1, if this is approved, will become lot 102. Amended lot 2 will become lot 1. I'm sorry. Amended lot 1 will become lot 101. Amended lot 2 will become lot 102. Again, of this Wagler Simple Subdivision. As I meant, again, as you know, the vacated portions of lots 102 will be deeded to and merged together with the adjacent unplatted tract of record. And the important thing is no additional lot or parcel will be created with this, should this be approved. Madam Chair, we have a number of findings. We recommend approval of this amended plat of this Wagler Simple Subdivision. We do have some recommended conditions that I can read in just a minute. I will mention that we have had conversation with the, tell me again, Marager properties to the east. You saw in the amended plat, there's a new easement that's being recommended. It's my understanding these owners are concerned about that easement. And I think the fact that it's just now being recommended to be only for agriculture use, I don't know if they're here today, but my understanding is they have some concerns about that easement, Madam Chair, just so you know. And we did receive an email from Musty Blau relating to that. Do you mind if I read the amended the conditions we're recommending?
No, that's fine.
Okay, number one is, again, should this be approved, this is for the amended plat of the Wagler simple subdivision. The applicant shall provide all easements as requested by applicable utilities and special districts, irrigation districts, or public agencies providing services. The width of any utility easement shall be sufficient to allow adequate maintenance of the system, but in no case shall shuts utilities may be less than 20 feet in width. Easements must be identified on the final plat. The applicant shall provide a deed granting the vacated portion of original lots 1 and 2 to Kelly Maragner and Teresa Maragner, specifically merging and combining the lands into Kelly and Teresa Maragner adjacent tract of record to be filed subsequent to and at the time of the amended plat filing with the Park County Clerk and Recorder. Number 3, the applicant shall provide a deed, whereas Kelly Maragner and Teresa Maragner grant the 3.3 acre unplatted lands to the applicant to be combined with and reconfigured into lot 101 of the amended plat of Wagler simple subdivision, lots 102, for filing subsequent to and at the time of the amended plat filing with the Park County Clerk and Recorder. And the applicant shall otherwise comply with standards in the Park County development regulations and the minimum subdivision requirements as set forth in Wyoming statute 185306. And we can answer questions should you have any.
Questions at this time?
You mentioned an email from, wow, maybe I'm not looking close enough, but I don't see it in the packet.
Yeah, this came on June 2nd on Friday, and it was from Rusty Blau, and it was essentially regarding the concerns that the Maragners had with this process. And because they will, Madam Chair, we bring this up because they will have to sign this for it, for it to be valid, for it to be recorded. And anyhow, we got the email on Friday, and it was basically that Mr. Wagner's, our understanding, according to Rusty Blau, wanted to move forward with this process.
But I guess my concern is I don't see it as part of this package, this packet.
We don't have the email.
We don't have it.
No.
It's part of the public hearing. I believe it should be included in the information we receive and the public receives. So
we did. Yeah, we failed to get it to you. That's our fault. I apologize.
Yeah, I'd like to see that information.
Madam Chair, it's would it help if I read it or not? Do you or Commissioner Livingston?
How long is it?
So it's 3 sentences from Jenny to Rusty Blau, and then 3 or 4 sentences from Rusty.
Okay.
So this was sent from Jenny, just checking to see if anyone has visited with Kim Wagler and the Maragners. We need to notify Molly today or Monday at the latest to take it off the BCC agenda if necessary. Please let us know what you might know. Thank you. Again, this went to Rusty. And again, because we know they have to sign this for it to go forward. Rusty said, Steve Fulweiler contacted Kim last night. I guess Kim Wagler still wants to move ahead with it as platted. I think they're still trying to come to an agreement on the use of the easement, but it sounds like this was the original plan and he isn't going to budge. I assume that's Kim does not want to change his mind. If this gets approved, but they can't come to an agreement, then I guess it will not get recorded because again, I assume they will not sign it. I believe Kim Wagler was going to call you and see if that is okay. I did not realize until today that Teresa is his daughter. Hopefully you've heard from them. I will be there for the meeting. Again, Rusty, we've not heard from, to my knowledge, from Teresa or Kelly.
Right. Yes. So I apologize. We were kind of waiting to get all the details and it just.
Okay.
Well, again, I just
And
had, when something mentioned that should be part of the package.
Yeah, I agree.
We should have that after the fact. And that's my.
Any other questions for staff at the moment? Okay, this is a public hearing, so if anyone else would like to speak on this proposal. If you'd like. Okay.
The problem is, I'm doing this for them. I was giving them back the land on the other side of the draw. I'm taking back the land the way it originally was. This land was never part of the farm. But now that they see they're losing the easement across the draw to their property, they don't want to lose that. It's something will work out. And I explained to them by an easement going through the middle of the one lot, devalues it, or devalues the lot a lot. But they don't understand that. But we'll have it worked out. We have a few months to get it worked out, I guess, but you know, they don't want the lots over there, but they still want the access through the property.
Kids.
I think. I think the problem that we have is if we do an approval today, that is what gets approved to be recorded. If anything changes that would be or affect that plat, it cannot go forward and would have to come back here. So are we better off postponing this until we get that input sorted out?
I've given them an agricultural easement and an easement to my grandkids. But when I sold them the property for a little bit of nothing, I said, you can never subdivide. So I don't know what they're thinking is if they want
Right.
a full easement across there. It's just evaluate mine and put more money on there. But they have a access through Arapahoe, but then the line would have to come through their property, which they don't want.
I
So
understand.
it's the family thing that we're gonna get worked out.
I understand that, except they have to sign the plat,
Yes.
whatever we
I understand that.
approve. So
Yeah.
I'm not sure we're ready to do a final approval if we're not sure what the final approval is gonna look like.
Madam Chair, my question kind of may go to staff here. Conditions 2 and 3. If those don't happen, if we approve based with staff conditions 1 and 2, if that agreement is not made, 1 and 2 can't happen, correct?
Yes, yes,
So
that's my understanding.
the commissioner chairman's point is, if we approve today and 1 and 2 doesn't, and the agreement doesn't happen, you gotta start over. You're okay with that?
Well, I'd rather not as long as it's taken, but the access was never, it was designated for those 2 lots on the other side of the draw. That's what originally designated.
Mhm.
So, you know, they're wanting me to give them access to that.
Do you think you can have this sorted out by the 20th?
Oh, yeah.
Madam Chair. Given that, I would make a motion that we we continue the public hearing until June 20th, 1:15 PM.
Okay.
Do I have a second?
A second.
Been moved and seconded to continue this public hearing until June 20th at 1:15 PM. To solve some issues. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes.
I thought you'd be opposed to
I'd-
run that.
He didn't think of that.
Okay.
Thank you.
See you,
Thank
Jim.
you.
All right, thank you, commissioners.
Thank you. We have a short break.
Well, I think it's covered, but
Well,
it's on here.
it is, but
And you said it was wrong.
here's my only thought there is if they go home, they sit down, they powwow. And they change one little thing. They say, okay, we'll agree if we change one little thing. Then he's got to start the whole thing over because we've approved this. We can't change. That's-
That's the end.
I know.
I just give it down.
Get a puppy?
Hey,
The difference is I want one and it's
they
like,
sold a dog
oh, yeah,
Pitchfork for sale for 10 grand,
yeah.
an unpapered collie, border collie.
Oh, my word.
I'm gonna.
They brought a dog out. I'm like, finally, something I can afford.
No, I can't afford the dog. So they sold a dog at the Pittsburgh sale and unpapered border.
I think the low selling dog was like 2,500.
Selling dogs?
Yeah.
They sold more than one?
Unpapered
3 of them. 10 grand.
Are they working?
for an
Are they
unpapered dog.
working stuff? But still, that's just
But the
ridiculous.
10,000 dog was unpapered.
Money,
Yeah.
was saying.
That's the same people that are spending $60,000 and $70,000 in geldings.
Yeah.
Then a 10-year-old at that.
How much? Oh, I said, it's the same kind of people that'll spend $60,000 or $70,000 on ranch gelding.
Yeah.
Yeah.
Well, you got a bar up there.
Like the one that spent 100,000 on 3 horses down there.
Yeah.
More money.
Hope they have insurance. Ah. We have about a minute to go and then we can get going.
What? All fun and games.
Yeah. Yeah, you guys are real fun.
Uh-huh.
So.
Living at my own house, I think Kim Wagner's over there at
Mhm.
half mile.
On the corner?
Yeah, well, we're Rick and.
Oh, yeah, okay.
I watched over one time, I saw his truck coming down off the hill on its own, through the fence, through the rocks and everything. And Teresa had been driving it, forgot to put it in park. And she was in about 8th grade. She got out and walked away and the truck went.
Oh. Ugh. Okay, it is 10:45. The next thing on our agenda is a public hearing for a variance request from Behringer.
All right, thank you, Madam Chair. So this property is in the North Fork planning area. The zoning there is GR 35. The requested action is a variance request approval. We did get the application in April of this year. That with the Behringers paid and provided information regarding the reason for the request. They talked about basically the necessity for the use of a construction home. They'll use an RV if this is approved on their property for more than 90 days. And they also explained the reasons and the manner for which the findings in our regs for how a variance can be approved, how those have been satisfied. So the applicants are seeking a variance that would allow the placement of an RV or construction home in the North Fork planning area for longer than 90 days. Of course, we have on the first page of the staff report, we have that RVs and campers are not permitted in the North Fork planning area when utilized for permanent living. We define permanent living more than 90 days. And in the North Fork, our regs do say that an RV/camper may be permitted there as a construction home for longer than 90 days, provided they get a zoning permit. But before that, of course, provided they get a variance approved to do that. I mentioned this is in the GR 35 zoning district. It is in North Fork planning area. RV campers may be permitted in this planning area as a construction home for longer than 90 days with a zoning permit and variance. So the location you see in figure 1, property is approximately 18 miles west of Cody. It's approximately 1,000 feet east of Witt Creek and Witt Creek Road. The property is adjacent to and northeast of Boulder Drive. Property's address of 90 Boulder Drive. Figure 2, you see neighboring land uses. A lot of residential vacant properties to the west because that is a subdivision. That is the Witt Creek Wilderness subdivision. There are some lands managed by BLM to the east of the property. And there is some ag lands just east of the property. And again, that's shown in figure 2. In terms of site characteristics, we have a map that's shown in figure 3, a topo map that shows the property is currently undeveloped. However, the applicant is currently building, I believe, their residence there. And they do have another, I think, shop or storage building on the property. They also have a permit for a permit to construct a septic. Essentially, the property is rolling hills. There is some change in elevation. And again, that's shown in figure 3, Madam Chair. Overlay, this property is not in any overlay district. So we have in our staff report, we have a paragraph from our regs talking about the purpose of a variance. Of course, it's to allow you the opportunity to grant people some flexibility should it be necessary from the strict application of our standards and our regulations. Applicability of a variance, of course, is up to the board to grant those if you feel it would deprive the owner of the land, reasonable use of the land, building or structure. Procedure for a variance, we have in our regs the procedure. Of course, we need to have an application. The application must explain the reasons and manner in which findings required for granting a variance have been satisfied. Variance requires a public hearing. Legal notices have been met, so this is a public hearing. Those notices were in the Cody Enterprise on May 18th and May 30th of this year. On May 18th, we sent certified notice to neighboring property owners consistent with legal notice requirements. We also notified agencies we thought would have possibly an interest. Public Works responded. They said they had no comment. We've not received any comment from Park County Treasurer, Game and Fish, or Weed and Pest, although those agencies were notified. Madam Chair, we have received 3 public comments. One public comment was from, I assume it was from a neighbor based on where they said they lived. One comment was from a neighbor who was in favor of granting the variance. Another public comment, again, I believe was from a neighbor based on their location. They were in favor of granting the variance. However, they had 2 conditions. And we did receive a third public comment, came, I believe, from a neighbor who requested denial of the variance for various reasons. They said precedent setting, the use is not consistent with county regs, not consistent with covenants is what they said. And they said the RV will likely not be aesthetically pleasing. Madam Chair, the variance standard approval standards is the county commissioners shall make written findings on the following 4 conditions, and all 4 of these must be met to grant a variance. And Madam Chair, so the applicants did supply us with what we called supplemental application information. You had a chance to read that. I just have in the staff report their paraphrase statements. Number 1 was the applicants have chosen to reside in Northwest Wyoming in part because of health considerations. Number 2 is their residence on Boulder Drive is currently under construction. However, it will likely not be complete, their residence, until late fall or early winter of this year. Number 3, they said to continue to rent a house while their home is under construction is exceedingly expensive. Number 4, the Behringers said living at their RV in a commercial campground also presents a health challenge to them. Number 5, the Behringers said parking their RV on their property along Boulder Drive should not be visible from any public road, and they said should not detract from the beauty of the area. Number 6, they said using their RV as a residence in the North Fork planning area requires a building permit, essentially, yes, from us, and an approved variance from you. The 4 conditions are, 1 is there are special circumstances or conditions which are peculiar to the land building or structure for which the variance is sought, do not apply generally to other land buildings or uses in the neighborhood. Our response is our conclusion is there really are no special circumstances or conditions which are peculiar to the land or the structure. However, we said it appears to be special conditions or circumstances that affect the applicants and generally do not apply to other land or structures in the area, and have not resulted from any act of the applicants, essentially their health concerns. We said applicants are affected by circumstances beyond their control, and we feel like a reasonable solution is possibly the temporary use of this RV as a construction home on this property in the North Fork planning area. Second condition, which has to be met to grant a variance, circumstances or conditions such that the strict application of the regs would deprive the applicant of the reasonable use of land, building, or structure. We said there are potential circumstances or conditions, again, health and building the residence, that could cause the strict application of the regs to deny the applicants of the reasonable use of the land. Without an approved variance, it appears the applicants will be unable to reside on their property until late this year. However, we also said if this variance is not approved, the applicants still have the ability to use the land consistent with our county regs, and that is a true statement. The third condition is granting of the variance is necessary for the reasonable use thereof. We said granting of the variance is not necessary for the reasonable use of the land. As mentioned above, the applicants have the opportunity to use the land in a manner consistent with our county regulations. However, it does appear without an approved variance, and we said this, the applicants may be unable to reside on their property until late 2023. The fourth condition is granting of the variance is in harmony with general purposes and intent of the regs and will not compromise the integrity of the land use plan, and it will not be injurious to properties, people, or detrimental to public health, safety, and welfare. We said granting of the variance is potentially in harmony with the general purposes and intent of the regulations, because our regs do point out that in the North Fork, even though an RV is not allowed to be lived in permanently, which is more than 90 days, our regs do talk about that can be achieved with a permit from our office and granting of a variance. It actually points that out. And granting of the variance appears to not compromise the integrity of the land use plan. Conditions for a variance, Madam Chair, in granting a variance, the board may impose conditions to prevent or minimize any adverse effects. Of course, then it talks about the effect of approval. If you approve a variance, other permits may be required. And then it talks about expiration of a variance. A variance shall expire and become void 1 year following the date of approval. The board may extend that for up to a year for good cause. So again, if you should grant the variance, you obviously can grant conditions on that. We have, Madam Chair, we have findings. We have a recommendation. We recommend approval based on the temporary nature of the request and the circumstances explained by the applicants. We're happy to answer questions should you have any.
Madam Chair, Kim, explain to me the zoning permit and how long it is, what the cost and how long is it good for?
So if you were to grant the variance, they would have to get a permit for this RV to be used as a construction home, just like other uses, just like other structures. The cost of that is $75. And Commissioner Teal, does that answer your question? Did I?
Partially.
Yeah.
You said like other permits, like an SUP?
No. So we have in our regs, of course, we require a building permit for any structure.
Right.
There are some uses which require the same permit, but it's not an SUP. SUP are for uses that have the potential to,
I'm just, if we pass the variance, I'm not following why they have to have a zoning permit.
Because it would be
it's in our rules.
Because yes, just like any other residence, they would have to get a permit from us, which we would give them because it's given by right.
But it's not temporary.
Well, so we have in our regs That's a good question. We have in our regs, we have a construction home definition. Okay, that's what we're talking about here. And again, if you grant this, you can condition this, but in our regs, a construction home is a conventional dwelling unit, mobile home, or RV, temporary occupied up to 1 year while a permanent residence is being constructed or reconstructed at the same site. So construction home
Okay.
is supposed to be for up to 1 year.
Okay, thank you.
I think it's interesting that that is in there, but yet they have the 90-day clause. Some things don't track completely. You have 90 days on this one and you have up to 1 year on this thing. I mean, most people can't build a house in 90 days and it's just not happening. But anyway, we'll work through it.
And build a house.
Well, that's true too.
Yeah,
That's
true. Yeah, true.
Anything else for staff at this time? Okay, this is a public hearing, so I would ask that anyone from the public that would like to speak, what I do request is that you state your name for the record, and if you would come up to the mic, please, so that everyone in the room can hear you.
Sad, online.
Okay.
Thank you for the opportunity to speak. We met with a number of
Your name, please.
Andrew Behringer.
Okay, thank you.
I am the person requesting the variance.
Okay.
We met with a number of the neighbors in the North Fork area, and they were willing and able to sign a petition request suggesting approval of the variance. I don't know if you can put that as part of the record or not, but we did talk to quite a few of the neighbors as well, and none of them seem to have any hesitation. Evidently, one of the neighbors mentioned it's against the covenant of the neighborhood. It's not. The covenant of the neighborhood specifically mentions you may stay in a RV construction for 365 days. So we did take that before we bought the property, but we're not aware of the zoning issue at that time.
What is your time frame, as you've stated? What are your thoughts?
The time frame for building the house, the foundation's dug, the footers are in. We're trying to get a plumber. Some of you are familiar with what that's like here. And the concrete guy said he's able to pour fairly soon after that, and then we're trying to get it insulated and all that. So we're meeting with a general contractor after this meeting today on site again to nail down the firm plan to get it enclosed and done by December 1st.
Okay.
So, but there is, you know how it is working with contractors.
Okay. Just for clarity, Kim, on the record too, there was a comment from one of the residents when they put in the conditions that they didn't mind it going on for a little while, but asked that the RV be removed as soon as it was done. And our discussion has to do with living in the RV when the home is being built. We have no control whether a landowner parks an RV at their home in their own yard. It's whether they're living in it or not is the issue. So I just want to be clear that that's what we're dealing with, not whether the RV stays parked there in the future next to your finished home.
One of the neighbors had mentioned that, and it's a covenant about that, and we talked to a real estate attorney down here, and they said that did not apply to our property, and so it's not necessary. But we have been keeping the RV at and buildings at a Brett's RV dealer and storing it there.
Okay, yeah, it might be in the subdivision next to you, but okay. Anyone else that wants to speak?
Just a question for the applicant. Well, first, you torturing your children by bringing them to a public hearing. So if we're looking at maybe October 31st, if we give a variance, you think you'd be okay with that?
I would suspect that it would be November 1st. I will be talking to the general contractor today, though, to try to get that nailed down.
Okay. Anyone else want to speak as part of the public hearing?
I'm chair, moving to close public hearing.
Second.
It's been moved and seconded to close the public hearing. Any discussion on the motion?
Wait, so I might want to continue this one.
Any discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay, motion passes. The public hearing is closed. Pleasure of the board.
Madam Chair, I move to approve the variance as written. It already has a 1 year limit on the zoning permit. And that would give them ample time to complete their construction and move in. With supply chain today, we all aware that construction of a home is difficult to get done in 90 days.
I'll second that.
Yeah.
Okay, I do have a question. On 1 year on a variance, my understanding is that is for beginning of the process. It is not a limit to the variance itself.
The zoning permit is only good for 1 year. That's the limit. It's already in there.
So after the variance, they're required to get the zoning permit, which does limit to a year. The variance does
Yes.
not. Okay.
And Madam Chair, the definition of the construction home, just so you know, it says up to 1 year.
Right.
Not necessarily 1 year, but up to that.
It expires a year from when they get their zoning permit, which they can't put a trailer on there and live it in until they get a zoning permit.
Correct.
Okay. So I have a motion and a second to approve the variance. Any further discussion? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay, motion passes. So if you would work with the planning and zoning office to finish the permit process, we'll be good.
Madam Chair, that's resolution 2023-26.
Good, thank you.
Thank you.
This is for us. Do you want us? If you, yeah, do you need a copy?
No.
Okay, we'll put it in the file. Good, thank you.
Okay. The next thing on our agenda is not a public hearing. It is Gillette Simple Subdivision number 300 final plat. Mr. Delavan?
Yes. All right. Thank you, Madam Chair. So this is the final plat review of the Gillette Simple Subdivision SS 300. Applicant was Rusty Blount, but an agent for the owners. The property owners are Don and Dana Gillette. This property is in the GRP zoning district, planning areas PAL. We did receive a final plat application from the Gillettes March 6th of this year, including payment, final plat, other documents. Revised final plat was received on May 24th. You see that in figure 1. So the applicants request approval of this. It will be 2 lots from an existing 20 lot parcel. And each of these will be a 10-acre lot. They'll be for residential use. As I mentioned, this property is in the GRP zoning district. The lot sizes as proposed are consistent with that district. The owners are the Gillettes. Again, you see in figure 1 what that final plat will look like. We do have a history on page 2. We have a number of different dates on here. I won't read those, but on page 2 of our staff report, we have an explanation of our determination of the proposed subdivision tract of record. This property is located approximately 2 miles south of Powell. It's south of County Lane 11.5. It's on the east side of Cope Trail. It's south of and adjacent to the Graceland minor subdivision 64. And you saw that location in figure 2. And again, you see it relative to Powell, essentially just south, a little bit west. Neighboring land uses, those are shown in figure 3. Neighboring land uses are primarily residential and residential/vacant lands. There are some agriculture lands west and south of this. And as I mentioned, there is Graceland just to the north, and there's another subdivision to the east of this. Proposed lots 1 and 2 are currently vacant in crop production, or at least they were when this started. Shown in figure 4, the topography is relatively flat, no change in elevation. This property is not within a mile of any municipality, so that review is not required. Notice of intent to subdivide, that was done back in July of 2022. So this is not the first time you've seen this proposed subdivision. We notified agencies. They were notified either by us or by the applicant. November of last year, DEQ responded with agencies should certain construction activities be proposed. Treasurer, again, this was in November of last year, property taxes not due. Park County Fire District 1 responded. They could provide fire protection. Park County School District responded. They said they could provide bus service. MDU said that natural gas is available. It was at the time going to be a new natural gas line on the west side of Coke Trail. Shoshone Irrigation District, they were working with the applicant on the water distribution plan. In January, we did receive an approved water distribution plan. Again, that was from the Shoshone Irrigation District. We did receive a summary letter and soils report as required with any subdivision from the Powell Clarksville Conservation District. Game and Fish has no wildlife concerns. Postal Service said they will be able to provide mail delivery service. Mary with Weed and Pest said a weed management plan will not be required. However, she recommends that the property owners adhere to best management practices. Public Works responded. They said proposal 1 and 2 will have legal access from County Lane 11.5 to Cope Trail. No, they said no new subdivision roads are being proposed. Public Works recommends the lot to be required to be part of an existing road maintenance road improvements association for Cope Trail. And they said the lots must be addressed with Public Works. TCT responded. They said the area is served by wireless internet. They can provide service, and then they have some conditions. Garland Light and Power in a letter May stated they have the capacity to serve the proposed subdivision. I know this isn't a public hearing, Madam Chair, but I don't believe in regard to this, we've received any public comments, not to my knowledge. So the Planning and Zoning recommended approval of the Gillette Simple Subdivision sketch plan in December of last year by resolution 2022. So there were several conditions. One was the applicant provide a response from Public Works. That condition has been met. Another condition was the applicant provide a response from the Postal Service. That condition has been met. Another condition was the applicant provide a water distribution plan that's been approved. That condition has been met. Another condition was a note on the final plat about wells. That condition has been met. Another condition was any access meet road and bridge standards and a right-of-way permit. A condition on the final plat. That has been met. Another condition was the Wyoming Right to Farm and Ranch Act. That language on the final plat, that's been met. Another condition was the applicant shall ensure that all easements pertaining to Cope Trail, in addition to the road maintenance agreement, are recorded prior to final plat review, and that condition has been met. Plat Review Committee, the Plat Review Committee met, had comments, concerns, questions on May 22nd. There were some minor corrections to the final plat. Then we did get that final plat on May 24th. So those concerns, conditions, corrections have been made. On page 9 of our staff report, we have submissions for final plat review. Obviously, the final plat, supporting documents. Subdivision improvements agreement, I will say, is not required in this case because there really are no improvements that need to be made. Final plat review did not require a public hearing. We have a number of different findings. We recommend, Madam Chair, approval of the final plat of Gillette Simple Subdivision 300. We have 2 recommended conditions. One is the applicant shall provide all easements as requested by applicable utilities and special districts, irrigation districts, or public agencies providing services. The width of any utility easement shall be sufficient to allow adequate maintenance of the system. However, in no case shall such easement be less than 20 feet in width, and easements must be identified on the final plat. Second recommended condition, the applicant shall otherwise comply with standards in the Park County development regulations and the minimum subdivision requirements as set forth in Wyoming Statute 18.5 306. And we're happy to answer questions should you have any.
Questions for staff?
I have one. So are they required and have they met the condition of the road maintenance agreement?
Yes, yes, they have. That's my
I see
understanding.
it's on the, it's required, it's as a condition, it says it's on the plat, but it doesn't say that. So that makes it official. It's just a recommendation that is from what from Public Works.
Madam Chair and Commissioner Gill, it was actually a separate document that was recorded, and this was part of Gillette South minor subdivision and Graceland, so it all came together just before all of this, so it has been a formal document is actually.
Okay,
recorded.
I just don't see where it says on conditions, staff, it says what they've met and it doesn't, it just says it's on the plat, but I didn't know if that made it official. It's just simply because you're using about a quarter mile of an existing subdivision road for the first part until you reach those, and it was recommended by Public Works that these two lots be part of that. And I just don't see it in black and white to me, that's all.
Gotcha.
But it is.
That was not clear on here, I apologize, but yes, it is all covered.
Yeah.
I think that's important to protect their.
Sure. I do remember it coming through with the other subdivision at this point. Any other questions for staff on this? Okay, this is not a public hearing, so in pleasure of the board.
Move to approve, Madam Chair.
Second.
It's been moved and seconded to approve Gillette Simple Subdivision 300 final plat. Any further discussion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. Okay.
Madam Chair, 23, 28. 27, sorry.
Yeah.
Sorry.
Yeah, that sounds correct. Yeah. Thank you, Colleen.
You're welcome.
The next one isn't a public hearing either, so I guess, Kim, whenever you're ready, we will go forward with the Gillette North minor subdivision 66 final plat and special improvements agreement.
Okay. Yeah, thank you, Madam Chair. So yeah, this is for your consideration, approval of the final plat of Gillette North minor subdivision and the subdivision improvements. The applicant for this and the owner of this property is Donald Gillette. This property is in the Powell planning area, the zoning district, GRP. We did get a final plat application in March of this year. Then we received, and with that application, of course, came that first version of the final plat. We received a revised final plat on March 29th of this year. That is shown in figure 1. So the applicant requests approval of a 2-lot subdivision, but it is a minor. This is one lot will be 12.86 acres and one lot will be 22 acres, both for residential use. Of course, the applicant also requests the board approve the subdivision improvements agreement. This is a build agreement, and this addresses utility, signage, and road improvements, is my understanding of what's in that SIA. And the draft subdivision improvements agreement was received beginning of May of this year. County Attorney's Office reviewed the agreement. Of course, Joy did, our planning director, and the county attorney granted approval on May 4th of this year. We have classified this as a minor. Donald Gillette and Dana Gillette are the owners. We do have, as I mentioned, we do have the final plat shown in figure 1. The location of this property, it's shown in figure 2. This property is approximately at 1.5 miles south of Powell, approximately a half mile west of State Highway 295. It's on the east side of County Road 10. That again is shown in figure 2. Figure 3 shows neighboring uses. Really, they're a combination of ag and residential in that area. There are some other subdivisions located close by. Property is not within a mile of any municipality, so that review was not required, which if it was, it would have been, of course, Powell, but they're not within a mile of Powell. I mentioned this isn't a GRP zoning district. These lot sizes as proposed are consistent with that zoning district. All of these are greater than 1 acre. The property is currently vacant irrigated cropland or at least it was. And in figure 4, you can see there really is no change in elevation. Figure 4 shows the topo map. This is, as you know, a final plat review. Public hearing is not required. So those notices were not necessary. We did notify agencies. Shoshone Irrigation District was notified. They provided in November of last year an approved and signed water distribution plan. Park County Weed and Pest responded. They have provided us an approved long-term noxious weed management plan. Garden Light and Power was notified. They said that easements for this subdivision, both easements have been signed. We've not received any public comments. The Board of County Commissioners reviewed and approved the sketch plan for this back in September of last year. You had a number of conditions when you looked at the sketch plan for this minor. I'll just mention a couple of these, Madam Chair. One was an approved long-term noxious weed management plan. That condition has been met. Your third condition was a review and recommendations from the Shoshone Irrigation District regarding the water distribution plan. That condition has been met. Your fourth condition was the approximate location of buried irrigation tile drain on the final plat. That condition has been met. Your fifth condition was a note regarding that buried irrigation tile drain. That condition has been met. Your sixth condition was a utility easement from neighboring property to benefit Garland Light and Power for the installation of power. That condition has been met. Your seventh condition was a condition on the final plat regarding access to serve the lot shall meet road and bridge standards. That condition has been met. Your eighth condition was following board approval of the sketch plan. Prior to your review of the final plat, the applicant shall submit an appropriate subdivision improvements agreement. That condition has been met. Your ninth condition was if lot 1 and 2 will share any improvements. So we have, for example, irrigation facilities. The applicant shall submit a draft homeowners association agreement prior to final plat review. Our conclusion is that's not applicable. So regarding these two lots, my understanding is there are no shared improvements. So an HOA is, in our opinion, is not required. Your 10th condition was a note on the final plat regarding wells. That condition has been met. And your 11th condition was the Wyoming Right to Farm and Ranch Act being on the final plat. That condition has been met. Final plat review occurred in March of this year. There were some changes and corrections identified. We did then get a revised version on March 29th of this year. That is in figure 1. We have submissions for final plat review in our staff report. And then we have a paragraph from regs talking about what is part of final plat review. Madam Chair, we have a number of findings. We recommend approval of the subdivision improvements agreement for this subdivision, Gillette North MS 66, as well as we also recommend approval of the final plat for this subdivision. We have a number of conditions that I'll read, if I may. Number 1 is the applicant shall provide all easements as requested by applicable utilities and special districts, irrigation districts, or public agencies providing services. The width of any utility easement shall be sufficient to allow adequate maintenance of the system, but in no case shall such utility easement be less than 20 feet in width. Easements must be identified on the final plat. Number 2, the applicant shall complete the terms of the subdivision improvements agreement timely and provide evidence of completion of all improvements to the Planning and Zoning Department. Number 3, after the terms of the subdivision improvements agreement have been met and the applicant has been notified as such by the Planning and Zoning Director, the applicant shall provide the final Mylar plat to the Planning and Zoning Department to be reviewed and signed by the Chairman of the Board of County Commissioners. Number 4, Once conditions 2 and 3 have been met, the applicant, in the presence of a member of the Planning and Zoning Department staff, shall record all required final plat submissions, including but not limited to the final plat and the subdivision improvements agreement in the office of the county clerk and recorder. And this will constitute then release of the lots for sale. So obviously, once the plat is recorded and the SIA gets recorded. Then number 5 is the applicant shall otherwise comply with standards in the Park County development regulations and the minimum subdivision requirements as set forth in Wyoming statute 185306. And Madam Chair, if I remember correctly, we recommend that should you choose to approve these 2 things, we recommend a separate motion for each one, but our understanding is they both can go into one resolution. Okay, thank you. And we're happy to answer questions should you have any.
Any questions for staff? Hearing none, accept a motion on the SIA to start with. Have a motion to approve the SIA. Do I have a second?
Who seconded?
Scott. That's Scott. Any further discussion on the motion for the SIA? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay,
Madam Chair, I move to approve the minor subdivision 66 final plat with staff recommendations.
Second.
been moved and seconded to approve Gillette North minor subdivision number 66 with staff recommendations. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Passed. Okay,
Okay, thank
thank
you.
you.
Thank you, Madam Chair. Thank you, commissioners.
Resolution 2023-28.
Thank you, Colleen.
Okay, we have a few minutes till Ben's due up here, so we'll give him a minute to get here. I know they had some meetings this morning. Interesting. Okay,
You gotta approve the subdivision agreement, improvements agreement is supposed to be approved before the final plat.
there have to be 2 separate motions according to Mr. Story.
If one fails.
It has been, believe me. Yeah, I'd like to talk about the loose dogs deal.
The what?
Loose dogs. The owners have more loose dogs than the renters do.
Everybody who goes, moves into a subdivision is requested to get a dog.
Yeah.
We're just getting lots of stuff right now.
Oh,
Well, and we don't.
Getting all kinds of weird questions.
It was still all seasons.
Good mood?
Huh?
You guys in a good mood?
No.
Hell no.
no,
Okay.
it's been a rough morning. Huh. You don't look like Ben. Is he coming?
Oh, no, Ben is tied up with the
Okay,
fence.
so that's who we have on the agenda. So
Yeah,
it's
yeah,
just
that,
checking.
I'm gonna be Ben all day.
Oh, okay. All right.
Trapper was you this morning.
Yeah,
Right.
that was me this morning, so
Just having all kinds of issues
they're out on the road as we speak.
on the South Fork. Okay. How many did they send this time?
There's 4,
4 of them.
less than usual.
Are you expecting any of the CMAC guys? Are you expecting any of the CMAC people to come in?
I doubt it.
We can probably go ahead. Okay, the next thing on our agenda, Brian Edwards, Park County Public Works. Bid opening for FY 2022 CMAC dust control application.
Thank you, Madam Chair. Just for the people that don't know, the CMAC stands for Congestion Mitigation and Air
Quality.
Quality. And so it's kind of a program the state uses, pretty popular with all the counties to get some dust suppressant applied to the road. So it's both a dust suppressant and it's also helps keep the road intact. So it cuts down on maintenance and the amount of time they've got to grade and that kind of thing. So pretty good programs. This is probably our 4th or 5th year since I've been here that we've been doing this. So this is for bids to put dust suppressant down, but it's basically for the product and application for 18.3 miles of county roads. And these things basically, this includes County Road 6CU, 6DU, which is Green Creek, 6WX South 4, County Road YXD, Hunter Creek, Lane 6 in Powell, Lane 7 in Powell, Road 4H in Powell, and Road 6 in Powell. So, yeah, we sent out, this is all comes through the state, administered to the state, and so they've got pretty specific bid requirements. We've advertised for, I believe it's 3 weeks in, I believe, both papers, and we received 2 bids.
Madam Chair, just for us as well as the press, that it is a grant.
Yes.
Matching or not matching, but it's an 80-20.
It's an 80-20, and I forgot to say that part. Ben correct me on this. So the total project cost is $109,680. The county's 20% match then is $21,936. And our engineer's estimate's based on 6,000 per mile, so that's gonna be key. If we go over that, we either have to cut back mile or something like that, so. Over there. First one is Dustbusters Enterprises out of Evanston. Okay, get listing mobilization costs, their price for the 18.28 miles is $6,975 per mile, which comes to $127,503.00. And that was Dustbusters. The other bid that we received. And like Colleen said, the outer envelope was open, but the inner was not open. So I think it's still a good bid.
And it's from,
This is, sorry, it's from Desert Mountain Corporation, Kirkland, New Mexico.
They're from where?
It's in Kirkland, New Mexico. I'll have to confirm, but I think they have a line. But so I'll have to confirm that. We'll flip a bunch of loose papers. Okay, so they did list a mobilization cost of $3,000 and an application cost for the 18.28 miles, $6,969.60. Yes, $6,969.60 per mile. And that works out to $127,404.29 for the application. If you add the mob to that, the total is $130,404.29. So what we probably need to do, just because there are so many requirements with this, let's take this back and evaluate everything. Make sure everything's current, and then I think prior to the award, we've got to get Y-dots and blessings. And then do that.
do you have to have a recommendation from us this afternoon then?
I'm gonna say no, because I'm doubting that me and Ben are gonna have any time.
Okay. Okay, so you'll put it on the agenda when you're ready. Okay.
I'm sorry, just a question. You advertise in the Palo Tribune and the Cody Enterprise, but you get applicants from New Mexico reading on these? I'm guessing YDOT also sends out info on it.
They don't, and I'm suspecting, because these are always the two we get. They're pretty much the ones that do dust suppressant work in our area, and I'm pretty sure they have a Wyoming. I think they're down in the same area, so I'll confirm that, but I believe they want some stuff pretty cool.
But I mean, there is another jungle drum out there where they're getting this information from.
I'll say this too, we do send it to them too. So when we get a request for proposal, we advertise in papers, and that's what we're required to do. But just like with anything else, we like to get the word out too. So when we know there's somebody that's done work for us, we'll send them a request for proposals. So I'm sure that's what they did in this case.
Madam Chair.
Yes.
Brian, the strict requirements by YDOT in the state to meet the qualifications for this. Have you had a chance to check to see if we can self-applicate through Granule?
I have not, but I know we got awarded for 23. We're getting ready to look at that again, and that's something we'll look at. We're locked in on these two, but on the next
right, we are. But moving forward, what I suggested was this can be put down whether it meets the state specs or not by Granule in our trucks that are built already for Sanders. And then we don't have to rely on an outside source. We can do all of it. They put it down in a granule, you prep it, we're prepping already anyway.
Yeah.
And then you work it in as a granule into the road base and you roll it back out and it's a done deal. And then we can work on it a little bit at a time without having to speak. I mean, it might be something if we can meet this, we can get more miles done for the same money.
And it is allowed, Madam Chair, what county or statewide of the counties that apply to this, which is most counties, I'm gonna say half of them do their own application now. Versus we always have to purchase just probably for convenience, and it's kind of like Fogsville, some of these others, we try not to,
But do they use Granule?
Oh, that's true, that they use liquid, so yeah, the granule's a different story.
Because then you're not stuck, because even if they're doing it themselves, they're relying on tankers and things like that. So it was just an idea that I've heard works very well.
We'll look into that the next time we apply for sure. We tried some samples of it. It does work pretty good. It doesn't take as much prep.
Okay. I just have to take into account the staff time.
Yeah.
Okay.
Right, but if we could also do it during our slow time.
Scott, you were asking about how they get from New Mexico. You get that with paper, you can't get that with radio.
They can pick me up in New Mexico.
Okay, with that, we will keep moving.
Thank you very much.
All right, thank you. I guess we got a few minutes before Brian Skork is due in. I'm sure, well, we can.
Who's the deputy regional forester for Region Two.
Oh, okay.
And state geologist was at our table.
You think?
I feel wilder party I got.
What's that?
How do you know that person?
Yeah.
Especially.
It's quite a place. Quite a place. Hi.
Do we have to read this right now?
Found my mini pen this morning. Yes.
Is this all mine?
Yeah,
Mhm.
3.
I found my mini pen I lost this morning.
The next thing on our agenda, with County Attorney Brian Skorick, IEC resolution.
Chairman, members of the board, so before you. I guess a draft resolution. Which will include. Both of the lawsuits, as the board might recall, there were 2 lawsuits, the county was contending with. Civil action 29727 and 30592. IEC was the main party in both of the cases. The county RNCC was listed as party in the first one, 29727. On May 8th, the judge in the first suit, amongst other things, ruled that this board's resolution 2019-10 is valid and enforceable despite the fact that the board never signed it or filed it. The court further ruled that resolution 2019-16 was void. So in essence, the property out that we were dealing with is designated industrial, and that's what 2019-10 did. As the board might recall, it was 2019-16 that then designated it GO35. So with this adverse ruling for the county, the parties then agreed just to basically settle all the remaining issues that were out there in both lawsuits. So what this proposed resolution does, it ratifies 2019-10, something the court already did. It voids 2019-16, something the court already did. But as part of the settlement, what it also does is reinstates the SUP 179 that the board had previously signed, but that had expired during the litigation. So where the county finds itself today, I guess, is where we were initially. So Hankins lawsuit has been dismissed. This lawsuit already has been dismissed. And let's just follow it up with the resolution and putting it all together.
So in essence, they're allowed to do what they originally asked to do.
Property that was zoned industrial with the and SUP 179 we put back and up back. No variance would be required since it's industrial. It really sums it up in, I guess, the last paragraph of the resolution. Questions?
I'm sure I have a question. Attorney Skorick, will we then put resolution 2019-10 and 2019-16 and attach them to this when we record this? Would that be the best?
That's entirely up to you. It probably might not hurt for people down the road trying to figure out what actually occurred.
That's what, that we kind of talked it over, but I kind of wanted to run it.
And you could attach settlement agreement and the judge's ruling, you could attach whatever you want to have.
Okay.
So we sort of reference those in here.
Okay. Madam Chair, would the board like us then to, since it is an agreement and a court paper, would you like us also to attach that to this resolution when we're recording the document? So it would be recorded as a whole.
Well, if we move forward with approval,
Right,
that
yeah.
probably makes sense because that gives a historical perspective to what's happened.
And then possibly on SUP 179.
And that's.
In essence, I guess what's contained in the resolution is what the county agreed to in the settlement. Paperwork. So we're not doing anything further today. I guess
Ratifying. Any other questions for any attorney?
Not constructive.
Good. Let's not go there.
No questions, maybe comments, but I'm gonna refrain.
We litigated that as far as we could.
Yeah.
Judge Stewart, Judge did, Madam Chair, I move to approve the settlement agreement, resolution, everything combined there that needs to be approved to move this forward.
Second.
Stop.
2023.
You're ahead of me.
29.
Okay, I have a motion and a second to approve the resolution as presented, with attaching the additional documents from the case. IEC, any further discussion? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay, thank you. Motion
It's a
passes.
little ironic because I was the only one that voted against it. When it first came in.
We're still
Don't live in the past, Joe.
Thank you.
Yeah.
Thank you for your work on that. And your
Thanks,
staff.
Brian.
No, actually.
You-
Added 29 and because you didn't see anything else.
Brian, do you need any of these copies back or are you okay? Okay, thank you.
Been requested over.
I'm not surprised. All right, we're ready to go to lunch in a minute. I guess Joey has a question. So we will recess for lunch. Okay.
Storage box. Oh, yeah, we can push the long ways. Yeah, I'd rather do that than.
Right. I agree.
Oh,
Agreed. Okay, it is 1:15, so we'd like to get going with the next thing on our agenda. Excuse me, if we can get started with our agenda, please. The first thing on our agenda this afternoon is a continued public hearing on the appeals of River Ridge subdivision. It's actually appeal on the road scenario for minor subdivision number 74. When we left off 2 weeks ago, 3 weeks ago, we stated that we would have the engineers start in with their information first today to bring us up to speed on any studies at anything that had been done on that road. So Mr. Edwards, if you would like to come up, and if there's any other engineering support that you have.
Yeah, I might get Rusty, if you want to come up with me too. We have done some traffic
Okay.
analysis since the last time.
Okay.
I apologize, I'm sweating profusely, but it's fine.
Yeah, somebody's doing some HVAC work up and we don't have any control over things right now.
Okay, first of all, I guess I'll try to be as brief as I can.
Use the mic, please, if you would.
Oh, I'm sorry.
Thank you.
I guess I'll give my whole spiel if that's okay.
Go ahead.
So my name is Brian Edwards. I'm a licensed professional engineer in multiple states and have been a professional engineer for roughly 30 years. As your county engineer, I'm responsible for overseeing more than 600 miles of road, 69 bridges throughout the county. I'm also responsible for acting as the commissioner's agent in administering and applying the Park County Road and Bridge standards. I say all this to say, I do know the difference between a duck and a swan. I actually kind of like ducks. Ducks are okay. Both Rivers Ridge Road and Corbett Road are ducks that do not meet county road and bridge standards for right-of-way width and for surface width. And it's important to note that that's the subject of the request for administrative relief. And that relates to both Corbett Road and Rivers Ridge Road. The fact that both roads do not meet minimum county road and bridge standards for surface width, the fact that both roads do not meet minimum county road and bridge standards for surface width and right-of-way width was stated multiple times throughout the response to the request for administrative relief, and in fact was the purpose for the request for administrative relief. And this is important. If an existing private road does not meet county standards or is deemed unsafe or dangerous, as some of the words have come out, it is the duty of those that use and rely on the road to improve and maintain the road. This is the neighborly thing to do, and this is the way it's done in Wyoming, or at least it used to. If a developer wants to substantially add to the use of the road in a manner that would cause, and I should emphasize the word cause, a change in classification of the roadway, then the developer is responsible for the cost to improve the road and all proposed lots fully participating in the current and future maintenance. So statements were made in the Doherty appeal that Rivers Ridge Road, unlike Corbett Road, is not now, nor has it ever been, a gravel road. So like any unpaved road in Park County or anywhere else, the surface condition of a road can change substantially depending on weather, use, and the level of maintenance. Mr. Harvey has provided receipts where he has personally purchased pit run material and gravel on more than one occasion over the years dating back to 2013, I believe, is when he moved in here. The incorporation of gravel and pit run renders the road a gravel road, which was my statement I made in my response to administrative relief. Statements were made that the surface has been road base and not gravel since 1993. And that admittedly, perhaps Mr. Doherty meant to say subbase or native material. In the road construction industry, road base is crushed gravel. On the occasions where I visited the road, and this relates to Corbett Road as well, I found the road surface to be to have a firm base. I had no trouble traversing the road in two-wheel drive. After heavy rain or heavy snow, the road condition is likely much different. I acknowledge that. This is true of any unpaved road in Park County, including county roads. The Doherty appeal also includes language that Rivers Ridge Road has never had scheduled maintenance, improvements, or significant repairs beyond occasional snowfall. With all due respect to Mr. Doherty, I'm not sure how the statement can be made by someone that has only lived in the area for roughly a year of the road/driveway's 30-year existence. In this 30 years, the condition of maintenance has been sufficient to allow those that regularly use the road to access their private homes. In other words, the homeowners that rely on the road have done what they need to do to get in and out safely. The parties that are the beneficiaries of the proposed subdivision are the ones that rely on Rivers Ridge Road for regular access to their homes and for emergencies. Admittedly, Mr. Doherty does use the road for to access to his fields and for irrigation purposes and whatnot, but his driveway is actually off of Corbett Road to his home, and that's where his address is off of. The appeal contains references, and this is again the Doherty appeal, reference to a 400% increase in traffic on Rivers Ridge Road. When evaluating the development's impact on road classification and use, we can only look at the conditions and demand at the time of development compared to the estimated traffic and use if a proposed development is approved. Unless previous development and use was illegal or not allowed by current regulations, how and when the previous development came into play is irrelevant to me in reviewing a request for administrative relief. Statements were made that both roads are dangerous and unsafe. It is my professional opinion that these claims are exaggerated. If the road is dangerous, then you could say the same about many miles of private and public roads, including county roads throughout the county. In the case of Rivers Ridge Road, has the road been dangerous for 30 years? Road driveway. Are there any records of accidents or traffic fatalities during this period? I asked Park County Fire District 2 Administrator Jerry Parker on whether or not they could get their trucks down the road in an emergency. He stated they could. He did caution that, like any road in Park County, their ability to respond to an emergency in a snowstorm is dependent on how the road is maintained, i.e. snow plowing, etc. It is worth noting that heavy construction equipment has used the road over the past several months. Statement was made in the appeal by Mr. Doherty that an easement is measured off the center of the road and the center line is meandering north. This statement is factually incorrect and cannot be stated without the benefit of a land survey. It is important that a distinction be made between the alignment and location of the road surface versus the location and alignment of the access easement, two very different things. The road alignment can legally exist anywhere within that 30-foot easement. No evidence has been presented that the road surface has meandered outside the 30-foot access easement. Statements were made that increasing the number of potholes during light rain and snowmelt makes this much worse. Again, this is true of almost any unpaved road in Wyoming. Regular maintenance, additional gravel, addition of mag chloride treatment, and other improvements can help mitigate this. Even the best constructed gravel roads require regular grading and eventually the application of additional gravel material. The appeal includes a reference to soil conditions provided by the Soil Conservation Service to Mr. Kim Dillvan, stating that limitations would be due to frost action and that the area would likely be prone to some ponding. That same paragraph states that this was not mentioned by Mr. Doherty. Overall soils are moderate to very favorable for local roads and streets for all three lots. Mr. Doherty had a problem with my statement that the road serves 3 users, and he said this was materially incorrect. Admittedly, I should have said 3 lots, including Doherty, and 2 addresses are accessed off Rivers Ridge Road currently for emergency response purposes. If the subdivision is approved, this will result in 3 addresses and 4 lots served. Per Mr. Harvey, the same residents and traffic that use the road now will use the road once completed. Once the house under construction is complete, construction traffic will go away. It is worth emphasizing that there are that if there were not an estate issue with the Herman Kroll tract or a financing issue with the house under construction, we would not be here today and the adequacy of the road could not be questioned. Either scenario yields the same traffic on the road before and after development construction. The traffic addresses and users will be the same regardless of whether or not the minor subdivision is approved. Once the house under construction is completed, the RV will go away. You'll be left with 3 residences using Rivers Ridge Road as their primary access to their homes. Statements were made regarding the 30-foot access easement and the relevance of the adjacent 20-foot utility easement. What I meant is that typically we see a 30-foot access and utility easement whereby the road and utilities are in the same easement. In this case, the adjacent 20-foot easement has the overhead power lines in it and possibly other utilities that I'm not aware of. This is a good thing and preserves the entirety of the 30-foot easement for access purposes. I was not saying that the utility easement could be used for access. And admittedly, I think there's Northwest Rural Water actually in that access easement, I believe. So statements made regarding the traffic estimates, and this is where Rusty comes in a little bit. Mr. Dougherty questioned my traffic counts on Rivers Ridge Road, and I believe Mr. Spadenko did too as it relates to Corbett Road. So my statements were made for Rivers Ridge Road based on 2 residences or really 2 addresses that regularly use the road. Since Mr. Dougherty's address and access does not use or rely on the road for primary access to his home, his was not counted, whether that's correct or not. Recent traffic data collected by our office as well as Morris and Merrily indicate that a 20 to 25 vehicle per day ADT for Rivers Ridge Road is valid, which is close to what I originally stated. Since construction is temporary, it is not factored separately. Still, whether it be 20 to 30 vehicles per day, the same traffic will use the road regardless of whether or not the subdivision is approved. The development will not increase the traffic and will not result in a change in classification per the Park County Road and Bridge standards. So when are upgrades to an existing road required? So quoting from Road and Bridge standards, if the proposed development will cause the maximum limits in table 5.1 to be exceeded on the adjacent roads, the developer shall be responsible for improving the affected road to a classification where the maximum limit is not exceeded. It's really, really important because that's right out of the rules. As it relates to Rivers Ridge Road, the traffic after development will still be less than 100 vehicles per day, but easily well under that. And that's the threshold between a local access road and a residential road. This is true even if I use Mr. Dougherty's estimates. Even with maximum future development considered, including splitting Dougherty's lot, the classification threshold would not be exceeded. Per Road and Bridge Standards, Chapter 3, Section 3 FI, hopefully I got that right, roads serving more than 4 parcels are not required to be built to county road bridge standards. Should this development be approved, it will serve 4 parcels, not more than 4 parcels, which would be 5. One could argue whether or not road and bridge standards should even be applied to Rivers Ridge Road. Admittedly, our road and bridge standards aren't perfect and there's some discrepancies throughout with that, but I just point that out. In the initial meeting with the applicant's engineering surveying consultant, this guy right here, they outlined the proposed layout and the number of lots planned, and this was in December. At that time, they proposed 4 lots instead of the current 3. And I have no reason or understanding or knowledge of why that was. I suspect it was helped to offset some of the costs of actually doing a subdivision. I guess was my thought. But anyway, at the meeting, myself and my project manager, Ben McDonald, were in there with Mr. Harvey and with Rusty here. And we told them at that time that with the 4 lot layout, Rivers Ridge Road would need to be constructed to at least the same standard and width of Corbett Road. This is because the 5th lot would trigger applicability of road and bridge standards. When reconsidering that the primary focus of the development was to facilitate estate planning between family, a revised development was presented by the applicant whereby 3 lots were presented. And we didn't hear anything from the December meeting through the holidays till I think late March is when we got the revised. So we didn't know that was the plan or what they were even attempting to do. So there was no secrecy on our part or no trying to cover anything up or bad intentions of any kind in there, which I've since talked to Mr. Dougherty, and I think we're on the same page that I don't believe he's implying that, but it's felt like maybe that we're trying to hide things or go around the rules in some way, and that just is not the case. The applicant has indicated they're willing to provide a statement on the plat that no future subdivision of lots will be allowed. Again, so quoting from the road and bridge standards, it says, these standards establish maximum traffic volumes for certain classifications. If a proposed development will cause these maximum limits to be exceeded on the adjacent roads, the developer shall be subject to upgrading the existing roads and be responsible for the cost of improving the affected roads. So statements are made in the appeal that the proposed development will change the classification of the roadway for Corbett Road. And I think this was in the Sponagle, hopefully I'm saying your name right.
Snoggle.
That's it. For Corbett Road from a local access road to a secondary collector road. This is factually incorrect. Both Corbett Road and Rivers Ridge Road currently do not meet standards for local access roads or residential roads. With that said, if the traffic does not change result from the development and does not cause a threshold for road classification to be exceeded, then the ADT is irrelevant. Before and after the development, both Corbett Road and Rivers Ridge Road will be classified as local access roads. Regarding Corbett Road, users having to participate in the maintenance of Rivers Ridge Road. This was not my intention to imply this. In no case would users of Corbett Road be required to share in the maintenance of Rivers Ridge Road. Park County has no authority or desire for this to happen. What was meant is that the users of Rivers Ridge Road shall fully participate in the maintenance of Corbett Road and Rivers Ridge Road. And Mr. Harvey has stated that the lot owners of Rivers Ridge Road are willing to enter into an agreement with Corbett Road land users to fully participate in the maintenance of Corbett Road should an agreement ever come into play. And I will add, it's my understanding that Mr. Harvey, and I'm going to get this wrong, Mr. Youngbauer, that those two and possibly a few others have regularly graded or maintained even Corbett Road through the years dating back to 2013. My understanding, that's based on what I was told. Regarding whether or not the existing 2 lots or proposed 3 lots have legal access to Corbett Road, I was probably incorrect in stating that they did have access to Corbett Road, even though the easement for Corbett Road east of the intersection with Rivers Ridge Road does cross into the adjacent subject property. And Mr. Sponagle did correct me on that, and he was correct. I was incorrect about that. Regarding the applicability of the 1993 and 2017 easements, the 1993 easement provided access to what is now Mr. Harvey's property, and the 2017 easement provides access for the benefit of Lot 2, which is the Herman Kroll tract. I suspect that prior to 2017, the road was considered by this office, my office, to be a driveway serving Mr. Harvey's property. Once 3 or more addresses utilize the road, then the driveway becomes a named road per Park County standards. Interestingly, our office had no record of when Rivers Ridge Road was named, but the road sign has been on their asset list for more than 20 years. Kind of odd. It was recently replaced and set on proper post by our sign technician. He took that initiative to do this and was not asked to do this by anyone in our office nor any of the landowners there. He just thought that it needed to be set up properly, so he did it. When Norman granted the easement, which Norman, I believe, was the landowner before Mr. Doherty, I think I got that right, granted the easement to benefit of Lot 2, conditions could have been made by the grantee to improve the driveway to a local access road standard as a condition of the easement, having no involvement from the county. This was not done by Mr. Norman, so apparently this was not a concern at the time. So sorry to be so long-winded, but in summary, the decisions reached by myself as county engineer are based on the technical information provided and available. These situations are lose-lose for myself and my office. I do not have a personal interest in either road, financial or otherwise. It is my intention to make an assessment and determination that is fair to both the developer and the adjacent landowners that are impacted while applying the road and bridge standards to the extent possible and practical. And again, I emphasize, if a private road does not meet a standard or is unsafe or dangerous, the adjacent landowners are responsible for improving and maintaining the road separate from any proposed development. In the end, the road and bridge standards are designed to make a developer pay for the cost to improve the road if the developer results in more than 4 parcels accessing the road, and if the development results in additional traffic which causes a change in the classification of the roadway. These criteria are not met in this case as it relates to either road. For these reasons, I ask that you uphold my decision to grant administrative relief to the road surface and right-of-way width for both Rivers Ridge and Corbett Roads. And I did have Rusty come up here with me since the last time we got together. And I think some people, I know Mr. Doherty is aware of this, we set out some traffic counters over the Memorial Day weekend. And both on Rivers Ridge Road and Corbett Road. Unfortunately, we have all our other many traffic counters out other places, so these might not have been our best units, and one of them, the battery crashed on us on Corbett Road. Just, you know, that's just how it goes. But we did get good data on Rivers Ridge Road, and we were in that 20 to 25 vehicle per day range. And we saw some discrepancies in our Rivers Ridge Road data between what Rusty collected. They put out trail cams, and theirs dated back to early May too.
We did 2 separate weeks.
But I think that where he had his camera and where we had our this for Rivers Ridge Road, we were picking up Mr. Doherty's driveway, and I'm not sure that his did. So that could be some discrepancy. Also, you know, wind and rain and dust. Who knows? You know, that there could be some discrepancy. Still, if I even use even the best, you know, error correction or whatever, anything from 20 to 30 vehicles per day is reasonable for Rivers Ridge Road. And, you know, both Engineering Associates in 2017, which was 50 some vehicles per day, admittedly was in a snowstorm. Admittedly, it was only a day of data. You know, they were 50 something. Rusty on his counts got 50 something, pretty close. 53, 54 was very close to that. If I apply the 38% error that seems to be from the Rivers Ridge Road, we'd still be looking at 75 vehicles a day on Corbett Road. So we're not increasing the traffic to the point at all, really, but in no way are we approaching that rivers or that residential road classification. Happy to answer any questions. Rusty, I didn't mean to take all the
Questions for
No, that's fine.
Brian at this time?
I got one, Brian. Are you, the number of lots is supposed to have a standard for the number of cars estimated to be
Yes.
for that development. So in your analysis of this, we're way under.
Yes, and as I explained to Mr. Doherty, we've studied this a lot, and this has come up on other requests for administrative relief. That 10 lots or 10 vehicles per day per lot that's in our road and bridge standard, that's your best case estimate when you don't have anything else. And so I was basing that on the 2 lots, and I didn't include Mr. Doherty's. But we found that depends on where you're located. If you're further away from town or something like that, those vehicles per day per lot goes down substantially. So it's a good average number, but it's not always real accurate.
So is our road and bridge standards are based on actual traffic or lots?
Lots,
both.
I'm gonna say both. We can, as a county engineer, I can request that a traffic study be completed. And probably,
That's where we are.
yeah, and if we would have done that, or if we would have been on that first submittal back in December, I probably would have requested that. If we were into some sort of request for administrative relief. But again, that's kind of my discretion on whether to do that. In this case, because there was not, to me, a reason of substantial change in traffic, I thought it would be a waste of developers' money.
Any other questions for staff? Okay, thank you.
Thank you.
Thank you.
I could just speak to the reason why it went from 4 lots to 3 lots, is because of the increase in.
Okay, that doesn't play into today, actually. We're just worried about the road at this
Time, we
point.
won't worry about it.
Okay, thank you.
Thank you.
So with the continuation of the public hearing, the first thing I would ask for is that people did not speak at the first hearing. If you have something you would like to add, please come forward. If you come forward to speak, please use the mic. Don't repeat things that have been said by others, please, in the interest of time, and please state your name for the record. So if there was someone that would like to speak that did not speak the first time first. Okay.
Thank you. My name's Steve Youngbauer, and I live at 35 Corbett Road.
Okay.
And other than Bernie here, I'm probably the longest living resident on Corbett Road, so I've seen some of the ups and downs, not like him, but some. I just want to clarify some facts on Corbett Road, which the county engineer may not be aware of. And I'll refer to his letter. First of all, the original public easement that was granted by Game and Fish was in 1969. And then in 2012, an additional easement was granted, which broadened those things that were granted, at least on that particular property. When that happened, the occasional fishermen that went down the Corbett Road, it all of a sudden it changed to commercial rafting and people going down. So there was a tremendous increase in traffic. So the infrequent or occasional use that's mentioned in the report, I want to clarify that that really is not accurate. When that started happening, some of us tried to, well, I personally bought some private road no trespass signs and put them up. Because not only were we getting people who are legitimately allowed to travel the road, i.e. the residents and the game and fish, you had other people using that road. And when I say other people road, I think that Mr. Daugherty mentioned last time that there's two roads out on the highway. One of them is the game and fish sign that points out to the Corbett Dam and for fishing access. The other is a sign that says National Historic Site Corbett Dam and points the way. Okay, I need to point out to you that there is no public access granted or easement that I'm aware of. They're granted to people who go and see that National Historic Site and use the Corbett Road. The other thing is that, and I know that Greg's addressed that, but on Google Maps and I think GPS, it's not discussed as Corbett Road. It's discussed as 2FE Road, which is a county designation of road. And I know the county reg specifically says, well, that can happen, but the general public think that that is a public road. I heard one of the things I take, I guess, contrary to what the county edge Mr. Edwards had to say, is I realize that typically it's the responsibility of the landowners to maintain that road in a safe condition. But what's been created here is not only do you have the landowners using the road, not only do you have the game and fish, you have the general public, those people visiting the National Historic Site, which I have personally talked and answered questions with people have gone by. And you have the general public that use that road for other reasons unrelated to the easement. Okay, now what I take contrary is we should not be required to maintain that road for the public. And most importantly, we are now being exposed, or landowners are being exposed to liability associated with an additional traffic that's being encouraged by those signs in the general public using the road.
Understood.
He said that people should enter into a maintenance agreement, and typically that's true. But when you have the general public using a road like that, it's unfair to ask us to maintain the road for the general public. And I personally, when I first moved there 9 years ago, I would have gladly signed a road use agreement. And but today, after looking at the legal liability associated with that has been encouraged not by us, but by others, I will continue to help maintain the road, plow the snow and do whatever necessary, but I'm not going to sign an agreement that would now subject myself to liability associated to the general public using that road. Right now, the landowners are on the hook, and I feel for them, but why should I expose myself to that? So I guess what I'm really getting down to is Corbett Road is unique from just about every other private road because of the game and fish easement, because of the National Historic Site, and because the general public uses the road. A lot of people just want to get out of town. And I sent a letter to you originally before the first hearing. I think it's dated May 12th. I hope you've had a chance to read that. And in there, I specifically asking you is that I think you ought to revisit the Corbett Road and making that a public road because of the reasons that I mentioned. So I would be happy to answer any questions you might have on that point. Oh, the last comment I would like to make is I've heard some outlandish and ridiculous cost of what it would cost to bring Corbett Road up to par, okay? Well, I think there's opportunities to do it at less expensive. I don't think you need to move the head gate out there for the irrigation. If you in fact move the road a little bit to the, I guess it'd be to the south.
Okay.
And you can make it wide enough. And there's in the county road, I'm driving throughout the county, I have seen easements or irrigation ditches within the county right away in more than one spot.
Okay, I think that's probably a conversation that we need to have, but it's probably not relevant to right now with what we're looking at with this administrative relief. But I do take your concerns with the Corbett Road and the Game and Fish. I think we do have an issue there that we probably need to look into a little bit farther.
And that's all
especially
I
when
ask you
dealing
to
with the
do,
public.
Madam Chairman.
Agreed. Anybody else have any questions for Youngbrow? Okay, thank you. Yes, Mr. Spinogle.
I gotta say something.
I know you do.
Okay, I'm Bernie Spinogle. I'm representing my son,
Mhm.
Michael Spinogle. There's a lot of history about Corbett Road. I was before the county commissioners 30 years ago on Corbett Road. And it was about, there was no legal access on it. I didn't have legal access, nobody else did. And so I brought that issue up. And because of that, in that meeting, we agreed as the county and the title company that we would give everybody legal access on a 23-foot road. I said 21, I compromised. But the issue is this, it was my call on the width of the road because that's what the width of the road was 30 years ago.
No.
And my vision was, I want to protect, in essence, a conservation easement.
Mm.
I want to protect Farm Unit C. Farm Unit C was not developed. There was 3 houses below me. And I wanted to protect the agriculture, the open spaces, the quality of life, and all of those things. And so now I find that my vision is not there anymore because people have rights. The county has regulations that is overriding my vision of that, so be it. But I'm saying all along that if somebody buys out there, they buy it, buyer beware, know what you're buying, know the access to it, understand that that's it, unless you have a reason to override it. So that's the first issue. The second issue is I'm concerned that this train has gotten off track. I worked for the Forest Service for 30 years. I know NEPA inside and out. I know how the process works. We used to do scoping to find out what the issues were, the issues and concerns. And we developed things from the scoping. This thing's gotten off track. Cattle guards are being removed. People saying, we'll do this. We're not going to do that. Access is questionable. The daily use on a road is questionable. To me, the horse died. We need to dismount and get back to the original. The original question why we appealed this was not to chase targets down the road. I appealed his decision. But now we're finding things have changed, and I don't know if we're adjusting to that or not, but that's a concern. And then the other concern I have is I want to protect the open spaces out there. It's a GR5. Now we're looking at a 1.57 acre with many homes and teeny homes and that kind of stuff. And that bothers me. And so be it. You know, if that's going to happen, and Corbett Road's a prime example. The utilities are in, the road's there. Everything's there for a developer to buy the whole south side of Corbett Road and put 21 houses in there. And if that's the way it's going to be, then we'll sell and move on. But think about it. You go out of town, you got subdivision, you got Reeds that breaks that up. Then you got a subdivision, Peaks Lane. Then you got Farm Unit C, breaks that up. Then you got Nez Pierce. And I'm saying it's time for the county to go back to your long-term planning and let's save some farmland around here, protect some of the open spaces that we all like to have and not develop it all the way to Powell. And that's all I have. Any questions?
The only thing that I would say is stay on board for the land use plan and where we're going with the regulation.
I've been through a
which
lot
is,
of land use plans.
Yeah, I know you have.
All right, thank you.
Yes, sir.
Lane 57 Corbett Road.
If you would come up to the mic, please.
How many minutes do I get?
just 3 or 4 where we need to,
I'd like to hear what Jim has to say.
we're not adding your time to his. That's not allowed.
You can transfer it to me.
No, you can't.
Mr. Root has his hand up too.
Okay. Mr. Roop, if you'd like to talk before Mr. Doherty, because he spoke at the first hearing.
I will have comments later when we talk about the subdivision and lot size.
Okay.
But as far as right now, I was going to ask if Mr. Doherty had my minutes, but if that's not allowed, then I have nothing to say right now.
Okay, thank you. Is there anyone else that did not speak at the first hearing or has not spoken today that would like to speak? Okay.
Well, the people in the room all want me to bring their message to the board.
That is not how that's normally done. We will let you start. We'll see where it goes, but you are limited. You had 22 minutes the first time.
In my email.
I know
that I was going to keep it on point and on topic, so I understand issues. Just level setting.
Would you please state your name for the record again, please?
Jim Doherty at 51 Corbett Road, and I'm going to stand because I want to point because it's a little light in here. This is level setting. Corbett Road in from 14A branches off to Rivers Road out to the Rivers Ridge development, and at the fork, Mr. and Mrs. Norleen are at 57 Corbett Road, so this comes into play. This was in the response. This photograph came from the response that the applicant submitted to show, in effect, this is Corbett Road, that it's not the standard as Mr. Edwards would say, but 2 vehicles in certain times of the year away from the poles can cross without problem. Okay, and so not having, or administratively for Corbett, maybe, okay, it's not off the charts, but this is Rivers Ridge Road. All right, same document. I didn't take the photograph, they did. And look at the same 2 trucks on the right. That truck is way over on a utility easement. You can't put 2 cars on that because he's got to run that way. This is a second photograph he included, also Rivers Ridge Road. You see those 2 blue markers. Okay, and he is well onto the utility easement at that point, right up against the fence in order to pass. This is those 2 blue markers. This is Northwest Water. The markers, they rise about 12 feet. They're surrounded by boulders. You can't be driving on that. You can't drive a fire truck across that and expect that that's that part of the accessible or access. Now this utility easement falls on Mr. Norleen's property, not mine. And in his letter to this board in May, he said, no, you can't use my utility easement for access, which is what's in the request. He conflates a utility easement with an access easement, and he opposes the grant of administrative relief. I know that I didn't get it surveyed, but this photograph kind of demonstrates the meandering that I'm talking about. When there is an obstruction, the traffic is meandering to the north into my property, onto my pasture. There's an irrigation ditch right on the side of that was obscured. So I may need a survey to demonstrate that, and you'll have time. Yeah. But that tells me, you know, I may not be a survey, but that doesn't look right to me. No, not in my time. Okay, it was in the summary.
Let's address all issues to the chair, please, not to each other.
There is a response that he paid $10,000 for a contract for maintenance in 2018. He said that in his response. And he includes the document with the circle. I gave $10,000. Well, wait a minute. $10,000 was the cap on the contract. The checks that he included were for about a quarter of that. Not $10,000, about a quarter of that. What did they get for the money? This again is Rivers Ridge Road, and this is approximately 2017 when the transaction was taking place. There was no access. The new buildings had not been put in. There was no road there at that time when he paid Gale Construction. Today, look at what has been added. Where did the $10,000 go? It was right up here by the new fork in the road where they had to raise the road on the right to match the left to build a fork to get equipment out to the site to build it. We talked about cattle guards at the last meeting. There was a cattle guard that I said was substandard for the fire department. Okay, it wouldn't hold a 35,000 reliable.
Would you please address me, not him?
Thank
you.
Okay, my apologies. And the owner then went after just prior to the last meeting and tore out the cattle guards, filled them in. Nothing. This is what I found on my property, May 28th. His horses roaming around now that the cattle guards and the gates are not being used. All of his horses up on my property. Well, thank you very much. Now I have to go to the expense of putting in cattle guards and gates to keep out, right? This idea of moderate maintenance, he would propose that I'm a suburbanite wants to pave Rivers Ridge Road. I didn't say anything about maintenance. The Cody Conservation District did. They said that moderate maintenance may be required on the roads. They did say that the roads inside the development are just fine. They're new. It's this that is the problem. And the owners themselves, we acknowledge that maintenance of Rivers Ridge Road is our responsibility. We're holding off on improvements until construction is completed. Meanwhile, it gets worse. Now, neighborhood outreach was part of his response. We did tons of neighborhood outreach. Well, with the meeting on the 8th of December, where they talked about all this, they had a public works meeting to talk about the road.
Mr. Doherty,
Yes.
please continue to address me. Do not address Mr. Edwards.
There was an email on the 13th from the county engineer requesting the measurements of the two roads. If it was gonna have to be updated, then he needs to get what are the measurements between Corbett Road and Rivers Ridge. That was a request that was made, a formal request. He also encouraged the owners to engage with the neighbors. Because in the past, there's been problems every time something's come up on this road. Encourage them, that's all he can do. Encourage with the neighbors to involve. On December 22nd, I hosted a dinner at my home. We're new to the neighborhood, my wife's in a wheelchair, we had to get people over to my house for the holidays. And all three owners were at that dinner with 15, 16 people. Talked about all kinds of things. What we never talked about was, oh, there's a plan for development and it's going to impact your road. Potentially at that point, that's all we knew. The next thing we know, we get a P&Z hearing, no outreach. When that comes along, they didn't talk to anybody. All of the applicants' outreach submitted was after the appeal was submitted. That's not outreach, that's damage control. Text from Ms. Herman to me the day after the appeal was submitted. Ms. Herman says, Jim, I want you to know we're planning to regrade Rivers Road when the weather becomes a little more predictable. We'll let you know when that happens. That was one day after the appeal was submitted. It's now 2 months later. Nothing has happened. Nothing. Now, I mentioned alternate access. Here is Corbett Road that loops around to the bottom, passing Mr. Norleen's house, or you can go up to the normal process to get to the development. This is that access right here, pretty attractive. And you can go from Corbett Road right into the driveway up to 28 Rivers Ridge. It's much better than Rivers Ridge Road. It's twice as wide, it's safer, all of those kinds of things. Here was the traffic counter that was at my driveway. It went from that new sign over to the marker. There was a traffic counter here. So people going down Rivers Ridge would cross over the traffic counter to be counted in the summary that he's looking at. Or you might go down Corbett Road, right, and go around to that back door that I just pointed out. Well, in order to go on Corbett Road, you're crossing private property to get to this access point, the back door. At the request of Mr. Norleen, we inserted a trail cam at the front of 57 Corbett, and this is what we were looking at. Applicants bypassing the traffic counter repeatedly, over and over and over again. Now, the first 2 days of the test, we couldn't get our own camera work. That's why you don't use cameras to track traffic. All right. I was getting a lot of bushes and magpies flying by and so on. But these are all the owners, the residents, intentionally bypassing the traffic counter. They don't have a right to be here. You also notice that they're kind of going in the same direction. You would expect to see somebody going out and somebody coming back. But that would lead to what on Rivers Ridge Road? Zero traffic. You don't want that. So we'll go out on one side, we'll come back on the other side, which leads to, and it's all of the owners that are involved in doing this. Plus, now if you go to UPS, Where does the GPS take them? Their GPS takes them around the back door to make deliveries to 28 Rivers Ridge. Now, potential reasons for trespassing using the back door. Well, the applicants have developed new interest in fishing and waterfowl hunting. Probably not. Surface conditions on Rivers Ridge Road are as difficult as I've documented. Property rights of the neighbors are not considered important to the applicants, or bypassing Rivers Ridge lowers the ADU counts during your study. And it's a lot. We don't have all of the or using dishonest methods to take something valuable. So here's a reason to reverse the administrative relief. All applicants clearly tampered with the study using the back door. That was not unintentional. This was new. We have lots of witnesses that have watched the incredible increase in traffic on the back door since the tapes were put out. There's a broad neighborhood opposition to this. Operating in bad faith, telling me $10,000 went into the maintenance of my road. I don't think so. Trespassing and doing this all secret. The volume of incorrect assumptions.
Mr. Doherty.
I'm sorry, there were several claims made that the engineer has admitted, maybe the number of users could have been different. But here's the follow-up. The failure of applicants to comply with the engineer's cost request. Paragraph 7 says the applicant shall provide all cost data requested by the engineer as required to provide a complete cost analysis. He asked them for the measurements to provide the cost analysis of what it was going to take to widen the road. They never complied. They never complied. From the start, because we're not doing that. But there was a formal request from the engineer for that data. They had no right to not comply. It says shall. So that's the end of my spiel. Questions?
Any questions?
Can I ask a question?
In just a second. Are there any from the commissioners? at this
Maybe
point?
just slide this one.
You can address a question.
When I was gonna ask you that question, when you had the picture up there that shows the easement, it shows the fence, am I correct that utility easements on the other side of the fence?
No.
Well, the fence divide the utility easement.
Yes, according to the owner. I am not the owner of that property. I'm sorry, if there is something that's 20 feet, it would, I presume, and this is okay. It would presume to be at the point of, contact with my property. So, as we've shown, they don't have a problem driving on it, obviously, but it's not a safe condition.
Okay, clarification.
Yes.
From what, well, from Brian, actually, from what you just said. We have the roadway that they showed. We showed the pickup a little bit off. Is that on a utility easement?
That's why I asked, we might want to get the only surveyor in the room to answer this, but my understanding is that this, if you can show that.
Yeah, I'll bring that up.
Is that's the divider of the property line between New Orleans and yourself.
Well,
which would mean that the utility easement is on New Orleans side. And so to me, I'm thinking both vehicles are sitting in the access easement, but Rusty might clarify.
With better enhancements of the photographs, you see, no. And here is that clearly is in the utility easement.
I see, I'm thinking that's in the access. I may be wrong.
That I could drive over this?
I'm saying that I suspect and Rusty could weigh in, but I suspect that is in the act, the Northwest Railroad.
With a 12-foot
Well, there
upgrade, it's up 12 inches,
Mhm.
surrounded by boulders,
Mhm.
and that was the way they installed it.
Keep in mind, that's not uncommon even in county roads, because you gotta separate easement from road surface. A lot of time we've got 60-foot right of way easements, and there's a 24-foot wide road.
So this
is a utility.
This has to be surveyed. I'm sorry, I fall back, but that would have to be surveyed as to where the center line is.
No, I would think at least knowing where the property line was, because my thought was that the 30-foot access on your property and the 20-foot access.
The important point, this all boils down to traffic. All this is kind of different. What boils down to is traffic, and this sample was tampered with by a significant number.
And one of the things, Madam Chair, real quick. In response to something Mr. Spinagle said, and he was correct, it's important to focus on that the administrative relief is the width of the road and the width of the easement. Those are the issues. I tried my best to address all the other things that were said, but those are the two issues.
Okay.
And then so you gotta ask yourself, is that traffic that we're talking about? Yeah, it was camper, I don't know, I'm not even gonna go there. But with the added together, are we gonna exceed 100 vehicles per day?
Okay, thank you. Thank you, Mr. Doherty.
Yeah.
Yes, Rusty.
Would you like clarification?
Yes, please. If you have clarification, that'd be great.
Rusty Blau with Morrison Merrily, hired by the applicant. The easement, utility easement is entirely on Orleans. I believe the fence is very close to the property line. I'd have to review exactly our data. It's within a foot or two of where the property line is. I'd also have to look and see if Northwest Rural Water, their easement is within the access easement. That's entirely possible. The utility easement from the previous subdivision was for the power line and telephone line and stuff. So I believe the fence is basically the property line at that point. The entire road is within the easement. That the ditch is also almost entirely within the easement. So there's I measured it at lunch off our data. From the beginning of the road, it was like 14 feet to by the end of the entrance of Mr. Harvey's property, it was about 18 feet from to the easement line back to the far edge of gravel. So there's plenty of room. It's within the easement.
Okay, thank you. Any questions for Rusty on clarification on the easement? Okay, thank you.
Thanks.
Yes, sir. State your name for the record, please.
My name is Ted Harvey. I live at 32 River Ridge Road. I just wanted to address a couple of Mr. Doherty's points today. He mentioned that we had a $10,000 contract with Gale Construction for the road. That was in 2018. My portion of that bill, which I provided check stubs for, was $2,700. I don't know the exact amount. The amount I paid was 1/3 of the bill, the final bill. The total bill was less than $10,000, but it was just under $9,000, I believe. Part of that construction also included the contractor taking road base, I don't know if that's the right word, from what was then Jason Fales' property before Doherty owned it, to save us some money rather than having to haul it in. That bill was entirely River Ridge Road. If you guys need it from us, we can provide bills for other excavation stuff that we've paid for the actual driveway on Cynthia and Karen's property. So that the part where he says we only spent $2,700 is just not correct. The part where he says that we spent that money mostly on construction is also not correct. That bill was entirely River Ridge Road. And Mr. Edwards had pointed out earlier that these roads need maintenance over time. It is true that we have not done any maintenance lately. We have been waiting for the construction to be completed, which has been stalled because Karen Crowell needs a construction loan, which she can't get until she divides the property. As soon as that's done, construction is going to be done pretty quickly. We have every intention of building the road or fixing the road. We're happy to sign something to that effect if need be. I guess that's all I wanted to point out. Rusty already pointed out that the access easement starts at the edge of Norleans property. The fence line that parallels that road, River Ridge Road, is right on Norleans property line. There is at the south end, close to where our properties meet, there is a survey marker which is touching the post on the fence. There's also a marker at the far end at the corner of River Ridge and Corbett Road. So that fence line is on the road or on the property boundary.
Okay.
The easement goes from that property boundary, the access easement goes from that property boundary 30 feet
across River Ridge Road. So the access easement actually includes pretty much all of Mr. Doherty's irrigation ditch that he talks about. The part where cars have swerved over towards his pasture to avoid pothole, there's no doubt about that. That's happening. Even though that's happening, no cars have ever come anywhere close to being outside of that easement. They have never gone in the ditch. It just hasn't happened. So unless anybody has any questions, that's all I had.
Okay, thank you. Any questions?
Thank you.
Mr. Doherty,
Just a comment, we have photographic evidence of tire tracks in the ditch.
thank you. Anyone else wish to speak in the public hearing portion? Anyone else wish to speak in the public hearing portion? I do have one question for Mr. Spinogle. Even though we're mostly talking about Rivers Ridge, I want to ask the question, with the years you've been out there, has anybody contacted the Game and Fish to help with the maintenance?
Yes, absolutely.
And?
We have, as the local people there, we have worked an agreement with the great, and they do, my opinion, more than their fair share.
Okay.
And, but we still, like
Right.
Mr.
I
Youngbar said, there's a lot of individual resources that goes into the maintenance of that road, but yes, they have
And-
done their fair share.
And the liability part, I understand. I just wanted to make sure they were involved. Okay, thank you.
Move to close public hearing, Madam Chair. Second.
I have a motion and a second to close the public hearing. Any further discussion on the motion to close? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. Okay, pleasure of the board, and our determination as to whether we agree with the appeal or we hold up the administrative relief. Commissioner?
I'd like to ask Brian just to reconfirm, in all normal circumstances, a road of this nature, I know it's exceptional, has exceptions, but would require a 60-foot easement and a 30-foot top, correct? In a surface ground.
Good questions. For the local access road classification standard, 30-foot right of way and a 24-foot driving surface. And that's the local access road standard. No shoulder, the 24-foot driving surface, 30-foot right.
When does it go to 60?
Goes to 60. Oh, I'm sorry, I said 30. It actually is 60. I'm sorry. I'm sorry about that. The 30-foot, I was incorrect, is the recreational road standard. And all of our other standards, local access road, residential road, secondary collector, they're all 60-foot line. It's all our county roads, correct? I apologize. It's 60.
And Madam Chair, I guess, this is different in a lot of, and I think Brian is trying to bring some common sense into this for his administrative relief. However, we've had these issues previous. And when development exceeds a threshold, like it or not, we put that on the one that tripped that trigger. Maybe this trigger was tripped a long time ago. I'm not comfortable 100%. I'm here to discuss granting administrative relief, because where do you draw the line? I mean, is this one of those exceptional circumstances? I mean, we've dealt with this before, and we're pretty much, I believe, unless memory serves me different, put a hard stance on when that threshold is met. If it's up to the developer that did it, they've done it before, to bring it up to the current standards. Now, we may have had some exceptions to that, but
yeah. And what are we considering the threshold? I guess.
Can I address it? That's where I kept stressing cause the change in classification. So we need to get over that 100 vehicle per day threshold to cause a change in the classification. That has not happened on either one of these roads, at least haven't demonstrated that's happening. I admit probably sometimes corporate road it probably does happen. But on an average daily traffic basis, I don't think it's over 100.
So in my opinion, that's the criteria, that's what kicks you into having to do something. Are you impacting that road to where you're changing the use of property? That's the way we read the rules.
On your traffic study, did you have a counter at the immediately off the highway on Corbett?
Unfortunately, our Corbett Road we did, but it got our battery died. So we did our data on Corbett Road did not.
So with the public's use, that could easily exceed 100.
I'm gonna say no.
No, okay.
Anything I've seen, because, and again, EA study, though it was only 24 hours, it wasn't a snowstorm, 50 some vehicles a day. And that was over a 24-hour period in 2017. And admittedly, trail cams, the accuracy, say they're off 30%. From what Rusty counted, 50 some vehicles a day. I don't think there was any end arounds on Portland Road. But 50 some vehicles a day, if I apply that error, that's 75 vehicles. So I don't think we're anywhere near 100 vehicles a day on an average daily traffic.
That's on Corbett. I'm sorry, the public part is closed, Mr. Green.
Madam Chair, what's the possibility of getting a traffic study out there with a traffic counter? It's got to get a battery.
It's doable. We could have if we had more time.
Well, we don't have to. We don't have to make decisions.
Yeah, and we don't have to do it. We normally don't do the traffic studies for a private road. That's the
Would we gain further information, we close the public hearing. So,
yeah, that's true.
I feel good about the data on Rivers Ridge Road, other than I don't know the whole issue of the vehicles going out the other end. I can't speak for that, but as far as the count on Rivers Ridge Road, it was.
pleasure of the board. Anybody want to trade places for a little more?
So I'm gonna ask us, what are the consequences for denial of administrative relief? Will the subdivision die?
I don't know that answer, and I don't know that we can base it on that or not.
I know
have
we can't,
no idea.
but that is the reasoning for this, of this administrative relief. Can they make
staff might be able
Joy,
to answer that a little bit.
Can they proceed with if
So the only
without the administrative relief?
The only way it would be achievable is if they could meet, I guess, the easement and width standard, which unless the other landowners are willing to grant them that easement, they would not be able to achieve it.
They'd have to widen to the 60 feet.
That's my understanding, is that correct?
That's correct.
Yeah, so if they have to do that, based on what I've heard, I'm not sure they could secure that additional easement.
Yeah. So. Madam Chair, this might help too. I don't think there's anything wrong with, because there's really the two issues of what the field is based on, the width of the right of way and the road surface.
Okay.
I think you could look at those two separate independently if you wanted, if it's possible to get within the 30-foot, 24-foot line plus keep the utilities. It's been done, but there's been a little longer for ditches and snow and all that.
So you're saying leave the right of way width the way it is, but do the road surface.
It's 20, I think you have that flexibility to.
And Madam Chair, we came up with a creative solution on Jody Lane, if you remember.
We did.
And we can kick around some of those options.
We can do that.
Am I out of, Madam Chair, am I out of line of asking the group a question?
No, go ahead.
Do you just not want this subdivided, or do you want the road in good shape?
Road.
Pardon?
Road.
You want the road in good shape?
What they do with their land is their business, as long as it doesn't create a problem for my road.
Your road being Corbett?
Rivers Bridge.
Okay,
Don't want it don't want it broken up. Don't want it broken up. Make them live within what they bought.
And the only reason I'm asking is we ran into this situation before on another road. We asked the developer, we didn't make them go up to the exact county standards, but we asked them, can you improve, are you willing to improve the road? And they are willing to come in and improve the road. And that's the reason I'm asking that question.
But but the issue is, if you grant it now, there's gonna be more subdivisions. And so who is officially gonna bring it to the standard? And right now, we have, the road counter issue is not representing sample. The battery was dead on Corbett. People were going around on the other end. You don't have good information to base a decision on, in my opinion.
okay, the other option that we have, because we did have the motion to close the public hearing, and the public hearing is closed. In order for us to gain more information, we have to bring that information back to the public for rebuttal. So if we decide that we want to do that, if you want us to do additional traffic counter things or do a little bit additional research, we need to reopen that public hearing. We can do that now through a motion, and we can set it for whatever date we decide we need to set it for, that we can get answers from the other people, or we can move forward with where we're at. Those are our two choices.
Sorry, I have a question, and maybe it's for Brian Rusty, I don't know. How long does a typical traffic study take? Like, is this
Standard for business. We spend a week getting, because that gets you weekend, weekdays and weekends, at the traffic. Summer's usually busier than winter. This is our traffic counting season. We've got about all over the county right now.
If we were to reopen the public hearing, we're looking at a July 5th date to probably have any answers or any further information. If that helps at all.
Oh, Madam Chair, I was gonna ask, there's nothing that says utility easements can't be under the road services center.
No.
In looking towards a possible compromise of widening the road. With yet an existing amount of, the easement that is there for all. You could, it's kind of a bearcat to maintain some of those utilities when that happens, especially if there's pedestals and water districts put them in the wrong place.
Oh, sir, wait a minute.
But I just wanted to verify that just because there's a utility easement doesn't mean you can't drive on it.
With the exception of, Madam Chair, qualifying that it would take your lanes granting access, because right now it is a utilities that your lanes do not have legal access to River Ridge Road.
And normally utility easements still allow the surface use to the landowner, not to the roadway.
Madam Chair, so like the couple things that are bouncing around in my head is obviously the traffic study. You know, I would agree that you maybe don't have complete information on the traffic study, but also it's been mentioned that the survey, there's a question of, is the road even where it's supposed to be? How wide is the surface? At what places? I don't know if it would be valuable for them to provide a survey that actually demonstrates what easements are, where they are, where the fence is, all of that stuff. Just to answer those questions, because that seems to be part of this discussion, as well. The third thing I've been thinking about, and I understand Mr. Harvey's intent is for estate planning, and that she, you know, obviously needs to get a loan to complete her home. And it is possible, I'm not certain, I would have to do some research, that they could achieve getting her moving on that with a mortgage exemption, where it wouldn't actually split the land, but it would provide a legal description that would enable her to get a mortgage. So I don't know if that's a possibility, because I can't remember the arrangement of who was what, but there might be something there to assist with that.
Mr. Harvey, because this deals with you directly and whatever decision we make, we're gonna have to work through. Would you want to answer that question, or?
Yeah, we've already tried to do the mortgage exemption and couldn't get it done without.
Okay.
Couldn't get one, I'm sorry.
Couldn't get a mortgage exemption. He already tried.
The only thing I want to say is, I think we could be happy to have a continued for another.
30 days. Okay.
Road study, whatever you call
The July 5th. Commissioner,
Madam Chair, I would move we reopen public comment.
Second.
been moved and second to reopen the public hearing on the,
July 5th, 9:35 AM. No, that was your motion?
That was my motion.
I thought so.
who seconded? Did you second that?
I seconded it.
Been moved and seconded to reopen the public hearing to be continued to July 5th at 9:35, where we will receive information on traffic studies and possible road width and easement information. That's the motion. Discussion on the motion.
Just to follow up on that, on the continuance, I would request on Brian's side, if they put traffic counters on Corbett and back door and
Both sides.
the other lane.
Any other discussion on the motion to continue the public hearing then, or reopen and continue the public hearing to July 5?
Madam Chair, did you say 9:30?
9:35. Hearing no further discussion, all those in favor?
Aye.
Anyone opposed? Motion passes.
I think no,
Madam Chair.
9:35. You're guessing?
Madam Chair,
Yes, sir.
how much trouble is it more difficult to leave them for 2 weeks, a 2-week period?
Really, we can get them set out right away.
I mean, you're gonna get it better
I
out
was
as,
just saying, we really can get them set out right away and up until couple days before the hearing, we pull them. So, and then, we can do the same thing again. The trail cameras at least helps give you some visual to go with that, so we'll do both the traffic counter and.
there seems to be quite a bit of questioning, a little more accurate.
Okay.
Precise.
Okay. Sorry, we're going to continue going, but we better have good information.
We permission from Papa first to get.
Thank you.
Precious counter.
Yeah, I can break that.
Tell them we don't want the battery traffic block.
Mr. Spinogle, I think you and I have experienced the same pain on that road.
Here's what we got. We got the. I know. And it just, it's like I say.
Just, I can't let it get argumentative.
My vision's gone.
Well, like I relate to that because all the years in the sheriff's department.
I know, it's,
I remember when Game Fish built the boat ramp down there with oops, because I just come on as a commissioner when they screwed that up.
Yeah, I'm gonna let you guys run that in. Yeah, it's just getting out of hand, and I just kind of protect what we have, and it's even a fight at a time.
Well,
Thank you.
It's
Thank
so
you.
difficult to understand how it can say private road and fishing access.
Yeah,
Those
and
just-
and going back to the comment, a representative sample, I can argue with that if you do the next week. Representative sample, you have a sample of all when the fishermen are in there, you have a sample in the summer, you have a sample in the winter, and so a representative sample, you're not gonna get it.
We'll get.
I mean, we're gone, there's one house is vacant and we're gone. There's 2 residences that aren't even driving over to the county.
Okay.
It is what it is. All right.
Okay.
That's kind of the point. I mean.
Okay.
Why don't you come sit here?
We're up to the,
T-ball.
I'm not that important.
No, you can be.
Oh, no. Way above my level of expertise.
now it's getting a little deep.
I have very little expertise.
Okay, the 2:00 item on our agenda, we're a little behind, but we'll keep moving. ARP, sorry. ARPA funds, ARPA funds, discussion on the sewer lagoons. I think we've known, Molly, Mr. Doherty needs to duck out behind you. You know that we have been talking about this for quite some time with the lagoons that are currently owned by Park County down off of Bighorn Avenue, that we are working with a contract with the city of Cody to eventually have them take over the situation with those lagoons, which means an upgrade to their lagoons to allow that to happen. So we have determined that the county would provide up to $2 million on a matching fund with a slip board grant that was granted to us. With the help of Mr. Livingston.
Yeah, what, the amount again, what?
2 million. With the help of Commissioner Livingston at the slip board, we appreciate that. It was approved. So at this point, we've had it kind of in a hold pattern. But we need to at this point commit to that 2 million coming out of the ARPA. I'll say 12 million. We don't have the other 6 yet, but the ARPA general funds account. Those funds are allowed to be used for anything that we could use general dollars for. So that is the thought process that we need to go ahead and confirm today that that is committed to that project. I'm not sure how soon the pay down will be. I know they're working on agreements and what it's going to take. And I know we've heard from the state that we can move forward. We just need to have this in place to be able to pay when we need to.
Madam Chair, we can provide an update with if you have
Want an update on the project?
Just a quick question, how much has the price changed since we first started talking about this?
It's a really good question.
It's 0.
Yeah.
Oh, good.
Thank you, Philip.
Not at this point.
Yeah, no,
We don't have any of our design completed yet to have updated cost estimates from the conceptual level work that EA has done at this point to generate some of the cost guidance from the previous documents.
One thing that I wanted to throw out that in our correspondence with Slim, there, and I know Philip got his letter on his project today, so we should get ours anytime now on the funding or the state ARPA funds. They've stressed that they want those funds to be used first, you know, so I kind of thought it would be, you know, a little bit of a match that they want all that money to be used as soon as possible.
Okay.
And so that might impact things a little bit.
Okay. Any other questions on the project? So with that, would entertain a motion to commit that $2 million in the ARPA general funds to the sewer lagoon project.
I'm not making it.
I will.
Yes, Commissioner.
Madam Chair, I'm gonna have a little discussion before my motion, and that's that, and give you a chance to think on what it is for discussion after the motion. If it doesn't die for lack of second. I believe this is a good way to, in the future, we're gonna have more expenses based on what we have. So we either need to walk away and let people fend for themselves or transfer the service over or minimum what with the grant, you know, but it will open up in the future to get all that money back in the land. Once it's reclaimed, is my belief, and it lowers our overhead for the future of the county. Therefore, I move to commit $2 million from the ARPA grant fund to the sewage lagoon transfer project, septic system, or what for the city of Cody as matching grant.
I'll second it. You had me going when you said we could just walk away. I was tracking with you.
Yeah, and we could convince me that we should. And then convince the about 10,000 residents of Park County that they gotta take it to Bidwell or Washington.
I think that's the issue. We're not talking about only people in the county. There's some people in the municipalities that still have septic systems too, that haven't made that change, but the city sewer. So it affects a lot of constituents that we have, including and the Forest Service and anybody else that has good well toilets in the area.
Camper parking on the street.
It's a huge,
it's
a huge situation. Have a motion on the floor to approve using the 2 million or committing the $2 million in the ARPA general fund dollars. Is there any further discussion?
Madam Chair, I've always been against us with the lagoon and basically wanted it just to go away. But I've heard that there is a benefit to the county. This is an investment, I guess, into the county, and maybe give the
poof keys to the city of Cody. Finally developing the Livingston Flats out there. So I do understand the benefits to the county, but we shouldn't have been in the lagoon business to begin with.
No.
And we're the only county in the state that does something like this. So I think that it's good to pass this on.
Move on.
So,
Okay. Any other discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay, motion passes. So those funds are committed. Okay.
Ben Junior.
What do you do? Ben?
Greg is Ben today.
Oh,
Thank you, everyone.
you bet.
You're up next.
Okay, Ben Junior,
That's not even.
project, Park County Public Works Department on the land auction sealed bids.
Oh, yeah.
You might remember that this is a parcel over off of 2AB that is pretty well landlocked, and we offered it to the two landowners. Had a little bit of a situation with how that sorted out, so we're back at the table to see how it sorts out today.
Thanks, Madam Chair. As you recall, yeah, I think we had a minimum bid on that last go round, and after kind of looking at that, the appraised value, there was quite a bit of discussion on how that appraised value could be quite a bit off, in that property's really only a value to those two tracks, because there's not legal access to it now. So anyway, I believe that was removed and we rebidded. We did receive one bid from John Andrew LLC, which I believe is the track that Keel owns. So I will open that now. Okay. John Andrew LLC is interested in the property that Park County has put out for bid with the following description. 0.33 acre parcel located in lot 50, township 53 north, range 101 west, Park County, Wyoming. We would like to place a bid for $11,000 on said property. This is signed Leslie Spencer, the business manager for Keel Sanitation. And it's John Andrew LLC doing business as Keel Sanitation. $11,000 is there.
Okay. Comments, questions, Brian?
Madam Chair, I move to accept the bid.
Second.
It's been moved and seconded to accept the bid from John Andrew LLC for the property in the amount of $11,000. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay, motion passes.
We'll get that in the
So,
works to make
yeah,
that
we'll get
happen.
a deed going and go from there.
Thank you.
Okay, thank you.
I think we're done, right? I think I'm done. Have a great day, Ben. Yes. Hey, thanks.
What's left of it?
Thanks, Darryl.
Walked into that.
Okay. Is there any other business to come before the board today?
Move to adjourn.
I'm
Madam Chair.
nervous when you hear.
Beat me to it.
Oh,
I just had
second.
Or unless you want to postpone to a for a later date.
It's been moved and seconded to adjourn. Any discussion? Hearing none, all those in favor?
Aye. Well, no, I can't sign that.
You can sign it.